No,
The
you
score
are
is not
amazing.
Rock star over here. It's like so busy with everything and then some.
Yeah.
So she's like, can I leave early from practice last night? And I'm like, oh yeah, sure. And then the next thing I know, it's like an hour and a half after I told her when she moved off, and we're still going, and I'm like, I'm brain dead at that point.
She's just like an energizer bunny.
I
She
know.
just goes. And we didn't tell each other yesterday, actually. We had a phone call. We were like, hi, you need to take a break for yourself. And you need to take a break for yourself. Okay, I'm gonna go start as PJ. Hi, good morning, I'm Simone. Nice to meet you. I'm so sorry. I promise I was not ignoring you.
No, you're fine, you're fine. I'm just
Thank you for joining us. We really appreciate it. We're gonna get started here in just a few minutes.
You need to ask a question that's, so a leading question goes, it's two leading questions like this. Your shirt is green. She goes, looks me and pauses and then stops because dude, her shirt. Comes right down. Sure.
And I was trying to explain the extrapolation and the rising load defense, and I have no clue.
I heard about that fact.
I'm like, I have no clue what I should be. I believe what I said. I'm pretty sure that, like, I don't know who was working with you.
They cannot
I'm like, all over the We're gonna have to swing back, but that's
it's kind of like the teachers who keep that weird course in summer school. They go, I just need to be far enough ahead where I'm ahead of the kids.
Probably in an hour and a half would be a good time. Yeah.
No, it's very short. Most years they still have.
Good morning. Good morning.
Morning.
We ready to proceed?
Yes,
Or do you
ma'am.
need another minute or so?
I actually need a minute. I need a moment. I'm sorry.
Just give us about 30 seconds. Our witness needs a moment.
I am ready.
Okay, you ready, counsel? Ready to proceed? All right, good morning. Calling the case of Nat Cole versus City of Blue Note. Can we start with appearances from the council, please? Starting with plaintiff.
Yes. Michael Betlock for the plaintiff.
Okay, good morning. And for the defense?
Julian Kranick for the defense.
Okay, and did all judges hear that? Yes, okay, thank you. All right, let's proceed with our opening statements, please, starting, do we have an opening statement from the plaintiff?
Yes, Your
All
Honor.
right, when you're ready to proceed, counsel. And I will be timing. So I will give you a 1-minute warning, and then ultimately I'll tell you when to stop. Actually, can you do one?
I can do that.
Can you time?
Yes.
Just so that way they
Yes,
can actually see.
yeah,
So you don't have to
absolutely.
look this way. And then just tell them to stop and sit. So. And it's Mr. Betlock?
Yes.
Okay, when you're ready, counsel.
Carelessness, chaos, and consequences. This is a case about a city that ignored warning signs about its police canine program. Again, again, and again. The city of Blue Note knew that that Max was not a suitable canine for a childlike environment, and they still decided to deploy him onto a school bus filled with children. And as a result of this carelessness, my client, Nat Cole, was injured. On October 25th, 2025, Nat Cole got on the bus, as he had done time and time again. Each school day, he rides the bus to and from school. On this day, he entered the bus and he walked down the narrow aisle He got in his usual seat, sat down, and the day seemed perfectly normal. Until the bus stopped, and that normal-seeming day turned into a nightmare. The door opened, and standing at the front of the bus was Officer James Davis and a police canine named Max. Officer Davis was there in his official capacity as an officer for the Blue Note Police Department. He was there conducting a drug sweep, which is approved by the city of Blue Note. Officer Davis had several options for how to conduct this drug sweep, but on this specific day, he chose to bring his canine, who has a history of aggression, onto the school bus and deployed him into a confined area. Officer Davis told the students, "Stay seated and do not touch the dog." Nat listened. While remaining seated, he briefly turned to look for his backpack. And seconds later, the canine was right next to him. It became tense. It barked. It then lunged at Nat Cole, biting him on the arm and holding on for nearly 3 whole seconds. This chaos ended with 13-year-old Nat Cole leaving the bus bloody, terrified, and with deep puncture wounds in his forearm. Now, as the plaintiff, I must prove a Monell violation by a preponderance of the evidence. This simply means that when you think of 2 scales, if the evidence tips even slightly in our favor, then that burden is met. To prove a Monell violation, the evidence must show 6 elements. The first element, that Officer Davis acted with the legal authority of the city. Second element, that the canine deployment constituted excessive force. The third, that the city's practice was the moving force behind the violation. And fourth, that the city acted deliberately indifferent to known risks. The fifth, that the city's inaction was the moving force behind Nat's injury. And sixth, that Nat Cole was indeed injured. The evidence in this case will address each element. Now, members of the jury, this case comes down to 3 specific points. First point, the city's careless lack of policies governing canine usage around children. Officer Davis causing chaos by deviating from his training protocols. And the lack of consequences that the department faced for their continuous informal practices. To get a better understanding of these points, you will first hear from Monica Alvarez. She was a former senior investigator for the city. Ms. Alvarez will testify about about deficiencies within the city's policies relating to canine usage involving minors, schools, and confined areas. She will also tell you that just 5 days before Nat was bitten, she warned her superiors that Canine Max was not suitable for childlike environments. Now, the defense will ask you to believe in this idea of comparative fault. This simply means that Nat was somehow liable for his own injuries. However, you will hear from Monica Alvarez that if the city had sufficient policies related to assessing canine risks, they would have likely substituted him for a better suited canine. Members of the jury, at the end of this trial, I will come before you and ask you to find the city of Blue Note liable for the injuries to Nat Cole. Liable for ignoring the warning signs again, again, and again. Thank you.
Thank you, Mr. Bedlock. Do we have an opening statement from the defense?
We do not.
Okay, thank you. Are we ready to proceed with the plaintiff case in chief?
Yes.
Yes. And are you giving a cross-examination of a
It's a
witness?
cross.
Okay. Then we'll start with the direct of the defense. Or,
If he has a direct.
I'm sorry, can I clarify? I should have clarified this beforehand. Counsel, do you have a direct examination and a closing argument?
Yes.
Okay, and who are you directing today?
Officer James Davis.
And who will you be crossing today?
Officer James Davis.
Okay, then we will forego the plaintiff case in chief. We will start with the defense case in chief then, have you direct examine the witness, and then have you cross-examine the witness. Understood?
Yep.
When you're ready, counsel. And can you say your last name for me one more time?
Kranick.
Kranick. All right, Mr. Kranick, when you're ready.
I left my 1 minute thing up there. Can you tell
Yes, that's fine.
Good morning.
Good morning.
Would you please state your name for the record?
Hi, my name is Officer Davis.
Officer, what do you do for a living?
Well, like I said, I'm a police officer. I've been in the Blue Note Police Department for 10 years, and since 2021, I've been a K-9 officer.
I see. And what dog are you assigned to work with in the department?
Max.
And what kind of services do you to provide the community?
Well, we usually run demonstrations at schools sometimes. We sometimes go to large gatherings like events where Max is there doing drug paraphernalia sniffing operations.
Expounding on that, why were you conducting a narcotic sweep for Blue Note Middle School on the morning of October 25th?
My department got note that there was a potential drug ring in Blue Note Middle School, and that some students may have had drugs on board that bus in their backpacks.
Officer, are you familiar with the Blue Note Police Department's pre-deployment policies for narcotic sweeps?
Yes.
And so you'd recognize that were I to show it to you?
I should, yes.
Referring court and counsel to what has been pre-admitted as Exhibit 7, let the record reflect I am showing opposing counsel. Your Honor, permission to approach?
You may.
Officer, what did I just hand you?
This is the my police department's pre-deployment policies.
I've highlighted some sections for your convenience. Could you tell the jury about these pre-deployment policies?
Right, so the most important thing is that prior to all of our planned operations, we conduct a briefing with all the other officers. What's important to note is that all of our dogs have to abide by training protocols and training certifications, which Max has met all of those.
And what does the record reflect about his obedience trainings?
Like I said, Max is consistently meeting all certifications, and
Officer Davis, my apologies. If you could refer to the highlighted sections to answer that question.
right, like I was getting to, he has met all quarterly obedience training certifications and is within regional norms.
How many again for the obedience tests?
Well, there are quarterly obedience tests,
Okay.
so every quarterly obedience test.
Officer Davis, could you please tell the jury in your own words what occurred on October 25th?
Right, so on that day, like I was saying, we were conducting an operation on Blue Note Middle School because we received word that the students there were actually involved in drug use and drug sales. I entered the bus with my K-9 with Max. As we entered the bus, it was a very narrow environment, very confined space. There were backpacks strewn all around. Max and I approached. We're going down the aisle, and then Max, being a drug-sniffing dog, is actually trained to perk up and bark when there is a scent change. And Max noticed the scent change when he approached Nat Cole's seat and backpack, and that's when the incident occurred.
And what exactly happened?
So Max reacted to Nat Cole. Nat made a spontaneous downward motion. I can't tell if he was doing it to reach for something or to conceal something, but this startled Max, and Max unfortunately bit Nat Cole.
Officer, why did Nat Cole come to Officer Max's attention that day?
Well, like I said, Max is a drug-sniffing dog, so he's trained to find drugs and detect them. And so when Max approached Nat Cole's seat and backpack, he noticed that there was signs of drugs in that backpack, and so that's why we were there.
I'd like to read into the record, Your Honor, stipulations 4 and 5.
Sure.
Nat Cole had drug residue on his clothing. Nat Cole's mother had a medical marijuana prescription. Officer Davis, I'd like to shift focus to Officer Max for a moment. Are you familiar with his 2023 to 2025 compliance record?
I am.
And you recognize that if I showed it to you?
Yes.
Referring court and counsel to what has been pre-admitted as Exhibit 12, let the record reflect I am showing opposing counsel. Your Honor, permission to approach.
You may.
Officer, I've highlighted some sections for your convenience. Your Honor, permission to publish to the jury.
You may. And this has been pre-admitted?
Yes. Officer, what does the record reflect about his yearly, or Max's yearly recertifications?
He's passed all recertifications in December 2023 and 2024. He's passed all quarterly tests for reactivity and stability and has been rated as stable. He's completed more than 16 hours per year in schools, buses, and crowded settings, and is noted as calm and controlled.
Time.
Thank you, officer. No further questions, Your Honor.
Thank you, Mr. Kranek. Cross-examination, Mr. Bedlock? And I'm pronouncing your last name correctly, right?
Yes, you are.
Thank you. And just as a reminder for our jurors, advocate number 1 is the plaintiff attorney, advocate number 2 is the defense attorney, just as you're going through the scoring sheet.
Dude, this mic mixes everything up.
We do have a podium on the other side, if you would prefer that. You can wheel that out to the middle area if you'd like.
Just so I can pick up my exhibit.
Oh, sorry, I was suggesting you can wheel that out this way. Yeah, you can move it so it's convenient for you. There you go. Or wherever you want to place it.
Thank you.
When you're ready, counsel.
Officer Davis, we are here today because Nat Cole was injured. Is that right?
Good morning, and yes,
Or more specifically, because your canine Max bit him?
he did.
Okay. Officer Davis, I'd like to start with talking about your relationship with Max. So you've been his handler since 2021,
That's right.
and you're the only person who can train Max.
More or less, yes.
Okay. Max is your day-to-day partner in the office?
Yeah, I take him home as well.
Okay. So you're pretty familiar with the way that Max acts, his behaviors?
Yes.
So with that familiarity, you understood, as Max being your partner, of how he would act on the day that you took him on the bus?
Yes.
Okay. I'd like to discuss your relationship with Max now. Forgive me, Officer Davis. I'd like to transition now and discuss previous incidences in which Max was involved with you as his handler. Referring the court and counsel to what has been pre-marked as Exhibit 1, let the record reflect that I am showing opposing counsel. Your Honor, may I approach the witness?
You may.
Officer Davis, this is Exhibit 1. Do you recognize this report?
I do.
How do you recognize it?
Well, Max is my dog. Every time there is an incident, I have to write a report, so I wrote some of these reports up.
Okay. Is this a fair and accurate depiction of Max's canine report?
It is.
Your Honor, permission to submit to evidence?
Any objection?
No, Your Honor.
So admitted.
I'd like to discuss the first incident on that report, which occurred in March 2022. You were at a school safety demonstration,
That's correct.
and Max bit a student there.
Yes,
The report lists the cause of that bite, right?
that's true.
The cause says it was handler error.
Yeah, that was on me. That's not on Max.
Okay. It also says that you failed to maintain proper control.
Yeah, like I said, that's
Your Honor, objection.
What's your objection, counsel?
At Federal Rule of Evidence 404, character or proper character evidence and propensity.
Would you like to elaborate on that?
Yes, Your Honor. This evidence rule disallows using prior incidents to prove present intent. This clearly is a line of questioning meant to show that Officer Davis was improperly handling Max then and now.
Response, counsel.
Yeah, Your Honor, it's undisputed that Max was already bit. The line of questioning is to show Officer Davis' knowledge leading up to the event, not to elaborate on Officer Davis's intent or the fact that Max might bite Nat. Like I mentioned, it's undisputed between counsel that he was already bitten by Max.
Just to clarify, are you arguing this set of facts for propensity purposes?
I'm arguing it to elaborate on the second element of a Monell violation, to kind of give the jury an understanding that Officer Davis had this knowledge, and so his deployment of Max in that environment constituted excessive force.
Understood. Mr. Kranek, I'll give you the final word, if you have any.
Your Honor, I believe this evidence is, again, going to show that Officer Davis acted in propensity with a prior character trait, and I believe that is inadmissible.
The court is going to overrule the objection at this time, but it is noted and very nicely argued with both of you.
Thank you, Your Honor.
Please proceed.
I'd like to move to the June incident, Officer Davis.
Yes,
You were at a traffic stop.
yes,
You deployed Max at this traffic stop,
I did.
and he bit a person at this traffic stop.
Sure.
Is that a yes?
I have here that Max made brief contact with a teen passenger.
Brief contact, okay. We can move now to the December 2024 incident. You were at a parade with Max,
Yes, I was.
and Max lunged at another canine.
That's right, another K-9 unit.
Okay. Is this custom at the police department?
I don't know what you mean.
Is this like a usual thing that canines get involved in, lunging at other canines?
I mean, they're dogs.
Okay. Thank you for that, officer. I'd like to transition now to the day in question. October 25th, 2025. You were on duty that day?
I was.
You were wearing the official uniform of the Blue Note Police Department?
Yeah, I was in uniform, so was, and Max had a harness on as well.
Okay. And you were conducting a drug sweep?
Correct.
Okay. And to conduct this drug sweep, you had the approval of the city?
Yes, it was a pre-planned operation. We were briefed on it.
Okay. Officer Davis, when you entered the bus, you were with Max?
I was.
The bus is not an open field.
No way. It was narrow.
Yeah. It's a confined area.
Yeah.
It's a pretty narrow aisle.
Correct.
Students possibly on both sides?
Absolutely.
Okay. In this type of confined area, you are required to maintain heightened leash control?
Yes.
You approached NATCO?
Max approached Nat with me. That's correct.
Yes. As you approached NATCO, you loosened your grip on the leash.
I did.
And less than a second later, after you loosening your grip on the leash, Max bit NATCO. Is that right?
There was an intervening event, but in that way that you said it, sure.
But it is true that
1
Max bit NATCO.
Yes, it is true.
Seconds after you deviated from your training protocols?
I would not agree with that.
Let me rephrase the question, officer. Max bit NATCO seconds after you loosened your grip on the leash.
Yes, but I would not say that Max bit Nat Cole because I loosened my grip.
But he did bite NATCO seconds after, is that correct?
That's correct.
Okay. And this was contrary to your training policies, to loosen the grip.
We're instructed to have a tight grip.
Okay. And as a result of all of this, Nat Cole was injured.
That's true.
He left with severe puncture wounds.
Unfortunately, yes.
Okay. Thank you, Officer Davis. No further questions, Your Honor.
Thank you, Mr. Butler. Any redirect for the witness? Actually, I don't believe you have time to do so, but. Any further examinations from either party at this time?
No, Your Honor.
Okay. And my understanding is that we do not have a closing statement, or closing argument rather, from the plaintiff. Is that correct?
Yes.
All right. Mr. Kranick, when you're ready, please proceed with your closing argument. If we just have 1 minute to adjust ourselves. Please proceed when you're ready. And Mr. Allen in the back will be your timer.
Thank you, Your Honor. Not every tragedy has a villain. What you've just heard makes clear this was an unfortunate accident, not the result of bad policy, inaction, or indifference. On the one hand, you have Officer James Davis and his canine Max, veterans of the department, made to undergo over 16 hours of environmental training in similar spaces to where the incident took place. Yearly recertifications and 8 separate quarterly evaluations for obedience and temperament. On the other hand, you have Nat Cole, a child. And I understand, we've all been that age where we like to push boundaries and buttons and see if we can get a reaction. And unfortunately, he did get a reaction. Let's walk through the incident. Officer James Davis and Officers Max board the bus with approval from the school, using policies that are consistent with regional safety norms. They begin their sweep, and Max comes alert to Nat Cole. Now this is very important. He did not alert to Nat Cole due to any reasons of aggression, but because Nat Cole had drug residue on his clothes, possibly left over from his mother's medical marijuana prescription. But at the time, all Officer Max knew was that it was his job to detect narcotics, and he did detect narcotics. Now, Matt Cole has the full attention of a trained police canine, and what does he do with that attention? He reaches, suddenly, against explicit instructions. Such a quick movement in such a confined space, any movement near someone is movement toward them. Now, to find a Monell violation, the plaintiff must prove three things in particular. There was a policy, which was the moving force behind the violation. There was indifference to the risk of the violation. There was inaction as to the risk of the violation. It is true that Officer Max has been involved with incidents in the public, yes, but none of these prior incidents, upon proper review of the police department, as per the testimony of Monica Alvarez, none of them established an aggressive pattern of behavior. How can my client be guilty as to inaction, as to the risk of a Monell violation with no pattern to indicate said risk? It is uncontestable that Officer Max must undergo 8 separate obedience and temperament evaluations, over 16 hours of environmental training, yearly recertifications just to continue working. It is not a logical inference to draw that a department with no care, or who was indifferent, in other words, to the result of their canine's deployment, would mandate such rigorous and consistent training. Now, former Lieutenant Alvarez has said some things about Max. She said she recommended that Max be taken off this assignment. She said she was dangerous. But what qualifies her to make that recommendation? She does not administer any of the obedience tests, the temperament evaluations, the yearly recertification, the environmental training. She does none of these things. She is not qualified to make that claim. Now, returning to the bus. We have explicit testimony from Officer Davis and James Johnson that proves that Nat Cole moved suddenly against explicit instructions. As well, we have evidence of such via the boys' Facebook posts. Such irresponsible behavior clearly breaks the chain of liability. Now, to find a Monell violation, the plaintiff must prove by a preponderance of the evidence that they can show, even a little bit, the evidence weighs in their favor, as the plaintiff stated. However, they cannot do so. Ladies and gentlemen of the jury, not every tragedy has a villain, and accidents do not automatically implicate fault. As such, I ask that you find the City of Blue Note not liable, as consistent with the evidence. Thank you. Thank you, Your Honor.
Thank you, Mr. Kranick. And I believe that concludes our round. I want to give all of you a round of applause. Excellent job. It was just a fantastic way to start off our day. So thank you all. Your preparation was very evident throughout this round. Again, we thank you so much for all of us. I think I speak for all of us. Thank you for participating in this competition in the first place. Thank you for all of your hard work and preparation. Thank you on behalf of the mock trial team for your interest in the competition and for being here today. Congratulations for making it to the finals. I want to encourage you all to join us at the reception tonight. It'll be in the, and let me get this correct. It'll be, here in the courtroom from 5:15 to 6 p.m. and it'll be at that time that we announce our top 3 winners. So thank you again. Another round of applause.
Thank you.
Thank you. And just as a reminder to our judges, we are streaming all of the rounds today, and all of our mics are on. Just as a reminder that we're on.
It's a long lens, so I'm gonna stand away.
Just at the table together?
Together, it's a long lens. Perfect. Thanks.
Congratulations again.
Thank you.
Now you can breathe.
Right.
And for our jurors, our next round starts at 9:45.
Yeah, have a good day.
Have a little bit of.
Thank you.
Thank you so much.
I filter all of the emails to its own file because
Is there about 15 minutes between each round?
Yes. Yeah.
So,
Because we wanted to make sure that we allotted for any objections or any
and
late start. That is so sweet. And then we just hit submit another entry, right? Ross?
Yeah, and you can redo it as many times as you want.
Okay, so this is round 2. It's 9:45 on the dot. Are we ready to proceed? Yes. Yes?
Yes, Your Honor.
All right. My jurors, are we ready to proceed?
Yes.
All right. Good morning. Calling the case of Nat Cole versus the City of Blue Note. Can we start with appearances, please? Starting with the plaintiff.
Yes, Your Honor. This is Simran Shergill for the prosecution.
Good morning. And for the defense.
Good morning, Your Honor. I'm Victoria Martinez, spelled M-A-R-T-I-N-E-Z, for the defendant, the City of Blue Note.
And can I just ask that you speak up just a little bit? I'm
Yeah.
slightly hard of hearing.
All good. Good morning, Your Honor. My name is Victoria Martinez, spelled M-A-R-T-I-N-E-Z, and I'm for the defendant, the City of Blue Note.
Wonderful. So just to clarify, Ms. Shergill? Is
Yes.
that correct pronunciation?
Yes.
Okay, Shergill and Ms. Martinez.
Yes.
Okay. Ms. Shergill, can you tell me what portions of the trial you will be performing today on behalf of the plaintiff?
Yes. So on behalf of the plaintiff, I will be doing the direct examination of Monica Alvarez and doing the closing arguments.
Thank you. And Ms. Martinez, on behalf of the defense, what portions of the trial will you be doing?
I'll be doing the opening and the cross.
Okay, so we got plaintiff, direct, and closing.
Yes.
And we have defense, opening, and cross.
Yes.
Thank you. Are we ready to proceed?
Yes.
Yes, Your Honor.
Plaintiff is foregoing their opening statement, is that correct?
Yes.
All right, so let's begin with Ms. Martinez and opening statement on behalf of the defense. Mr. Allen, in your back left corner, is going to be timing you during your opening. He'll give you a 1-minute warning, and then he'll tell you when to stop, so just look for his cue. And just so that both of you are aware, there is a movable podium right here. If you'd like to use that, instead of using the more stationary one, use this, move this around at your preference.
Okay. Thank you.
And Ms. Martinez, proceed when you're ready.
Out! Officer Davis commanded Max to disengage from the bike. Max did so 2.7 seconds later. Those 2.7 seconds never should have happened. The City of Blue Note accepts that. We accept that 13-year-old Nat Cole was scared and ultimately harmed on October 25th, 2025. This case is not about denying a tragedy. This case is about determining whether the City of Blue Note was unreasonable and deliberately indifferent when it came to the safety of its children. Today, plaintiffs must prove 6 elements to you, 2 of which were that the city was unreasonable and that the city was deliberately indifferent, meaning that they consciously disregarded signs of danger. If plaintiffs cannot prove either of these elements, you must find the city not liable. So I ask you, what is reasonable to protect the children of Blue Note? Is it standing by while drugs run through our schools? Is it standing idly by while a student-run drug ring operates in this city? Or is it doing something? The City of Blue Note chose to do something. This is Officer Davis and Max. They're a trained canine unit used to prevent drugs from flowing into our schools. You will hear from former senior investigator Monica Alvarez, who reviewed canine program for the city, as well as Max's training history, his history being consistently positive. You will hear from Officer Davis, who will tell you about what happened that day on the bus. Their testimony will show you that what happened while distressing was not deliberate indifference. The city admits it was imperfect, but the law does not require perfection. The law requires reasonableness. This memo shows that before October 25th, 2025, K-9 deployments such as this one were consistent with regional norms and training expectations. You will hear from Lieutenant Daniel Whitlock that the city was acting within reasonable professional standards. Plaintiffs will tell you that risks existed, that warnings were raised, but members of the jury, when you hear the evidence today, you must remember that risk alone is not the same as deliberate indifference. Doing nothing was not an option. Again, doing nothing was not an option. At the end of this case, you will see a city that chose to act to protect its children. What happened was undeniably tragic, but it was not deliberate indifference. It was a flawed effort to do something rather than nothing. And sometimes doing something is what reasonable looks like. At the end of this case, we ask that you return your verdict for the city of Blue Note, a city that chose to do something. Thank you.
Thank you, Ms. Martinez. Plaintiff, is your case in chief. Ms. Shergill, the direct examination of your witness when you're
Yes,
ready.
please. The prosecution would like to call Monica Alvarez to the stand.
Just give us a moment. Mr. Allen is doing double duty today,
Nice.
so.
We just had a little identity crisis.
He was the officer in the last round, so.
Okay.
And I'm sorry, the name of your witness one more time.
Monica Alvarez.
All right, Ms. Alvarez. Ms. Shergill, when you're ready.
All right. Good morning.
Good morning.
Can you please state your name and spell your last name for the record?
My name is Monica Alvarez. Alvarez spelled A-L-V-A-R-E-Z.
Mr. Alvarez, what role did you have at the City of Blue Note?
Yes, so from 2021 through 2025, I was the senior investigator with the City of Blue Note's Department of Public Safety and their Critical Incident Review Board.
And what were your responsibilities in this role?
Right, so I reviewed the use of force of our various police departments, including assessing appropriateness of canine deployment, as well as identifying gaps in policies and training.
Referring Gordon Counsel's attention to what has been pre-admitted into evidence as Exhibit 1, this is the canine report of the canine, Max, showing opposing counsel Exhibit 1. May I approach the witness?
You may.
Mr. Alvarez, what is this document?
This is a canine incident report.
Permission to publish Exhibit 1 to the jury?
You may.
And let's talk about these incidences. What are the dates on these?
So there are 3 in total. The most early one is March 2022, followed by June 2022, and the latest one is December 2024.
Let's talk about each of these. What happened in March 2022?
So in 2022, there was an incident reported that the canine officer, Max, bit a student at a school demonstration due to improper handler control.
And what happened in June 2022?
This was during a traffic stop. Also, K9 Max was involved. There was brief contact with the teen passenger. Max was aggressive towards the teen passenger.
So sorry about that. What happened in 2024?
This was during an annual holiday parade. This incident involved K-9 Max as well as another K-9 unit.
Just to be clear for the jury, how many of these incidences involved a minor?
From my recollection, there are 2.
And did the city of Blue Note have any policy regulating the conduct of a canine around minors?
No, it was no official policy. It was sort of verbal and informal.
And in your role as senior investigator, given these incidences, what were your concerns?
Well, I took issue with the fact that we had no written policy. Although Blue Note did follow regional norms, as a risk assessment specialist myself, that didn't seem like a good idea. So I warned the city multiple times that we should create actual written down policies, formal policies.
Referring court counsel's attention to what has been pre-admitted into evidence as Exhibit 5. This is an email written by Monica Alvarez showing opposing counsel Exhibit 5. May I approach the witness?
You may.
Mr. Alvarez, what is this document?
This is an email I sent to one of the police department lieutenants.
And permission to publish Exhibit 5 to the jury.
Is this pre-admitted?
Yes.
Okay. Yes.
And when did you write this email?
I wrote it October 20th, 2025.
Why did you write this email?
I wrote this email because I've noticed several incidents and instances where K-9 Max was involved with biting teens, or minors rather, and I wanted to bring that to the attention of the police department and warn about his temperament.
And who did you send this email to?
I sent it to Lieutenant Whitlock.
Anyone else?
I CC'd Officer Davis, the handler of Max.
And did they respond to your email?
You know, I don't remember. You'd have to refresh my recollection. I'm sorry.
Would you like your affidavit for your recollection?
Yes, please.
Here's your affidavit.
Oh, right here. Okay.
Has your memory been refreshed?
I mean, not really.
Okay.
They didn't really take my concerns seriously, if that's what you're asking.
Exactly that. Did anything in the department change after you sent this email?
Nothing.
And did the police department ever implement any of your changes that you recommended?
No. In fact, they fired me.
All right. Let's talk about the incident.
1 minute.
I'm sorry?
You have 1 minute remaining.
Thank you. Let's talk about the incident at hand. Do you remember what happened on October 25th, 2025?
Yes, Blue Note Police Department were conducting a drug sweep on a bus for Blue Note Middle School, and there was a bite incident involving minor Nat Cole.
Referring court counsel's attention to what has been pre-admitted into evidence as Exhibit 3. This is a post-incident review emails. Exhibit 3. May I approach the witness?
You may.
Here's 6. Mr. Alvarez, what is this document?
This is a post-incident review email
And what was the final conclusions by the board on this email?
that Max acted within policy.
And did there exist a policy that was regulating the conduct of a canine around children?
No.
Did this review recommend any change?
No.
Any reassessment, retraining?
No.
No further questions, Your Honor.
Thank you, counsel.
Thank you.
Cross-examination from the defense. Ms. Martinez, are you cross-examining Ms. Galvez?
Yes, I'm cross-examining Monica Alvarez.
Oh, I'm sorry, Ms. Alvarez. Yes, when you're ready, please proceed.
Thank you for bearing with me.
Of course, take your time. And again, feel free to use that podium if you need it. It's there at your disposal.
Good morning, Ms. Alvarez.
Good morning.
You worked for the city of Blue Note.
That's right.
You were a senior investigator.
I was.
You've already mentioned that you investigated this incident in particular.
This one in particular and many others.
For this investigation, you would have referenced different records.
Of course.
A record including Max's training record.
Correct.
If you saw this today, you would recognize it.
I would.
Referring court and counsel to what has been pre-admitted as Exhibit 12. Showing opposing counsel dissent. Your Honor, may I approach the witness?
You may.
These are Max's training records.
Correct.
You've seen them before?
Absolutely.
They are true and correct.
This is.
Permission to publish to the jury.
You may.
These training records are from 2023 to 2025.
That's right.
This is after the 2022 bite incidents referred to earlier.
Objection, Your Honor, propensity. Counsel's.
Would you like to elaborate?
Yes. Counsel's trying to establish that just because Max was passing these trainings in the past and these acts of certifying, that this incident is just like that. He's passed training and not acting within reason.
Ms. Martinez, any response?
Your Honor, for a propensity objection, it only applies to people. But in this case, I'm using Exhibit 12 and also referencing Max's history to show that the city, well, as offer proof,
Yes,
the
thank
city is responding to incidents that have occurred with training and by exposing Max to environments that he needed to be exposed to, such as a child environment, such as confined spaces, and that they weren't unreasonable. They didn't send a dog that hadn't been trained at all. They sent a dog that they trained extensively and that had positive reviews out into the field. And this case is about whether or not the city was acting reasonably.
Do you mind reminding me what your question was before the objection? If you recall.
It was, one second, sorry, or one.
That's or just the topic
The
specifically.
topic specifically, I referenced that these dates for the training 2022 to 2023 to 2025 are after the 2022 bite incidents.
Understood. Any response? I'll give you
Yes,
the final word.
I'm precising my propensity objection. It's that the city's policy has been consistently this way, and that because this policy has been consistently pursued to certify Max these countless times, that this one time, if I may offer a bit of proof,
Yes.
that this one incident was during a certified policy that, was consistent with the ones in the past, when we're saying that it necessarily wasn't.
Understood. The objection arguments are very well taken from both of you. I'm going to overrule the objection at this time.
Thank you.
Ms. Martinez, please proceed.
These trainings are from 2023 to 2025.
Yes.
This is after the 2022 bite incidents.
Correct.
So these trainings took a span of 3 years, give or take.
I mean, I'd say 2 years, but yeah, sure, 3.
In these trainings, Max was trained for reactivity.
Yes.
He was trained in school environments with children.
Yes.
He was trained in confined spaces of a bus.
Among other things.
Additionally, for these trainings, there were monthly evaluations.
Right.
In these monthly evaluations, they would have, well, as we said earlier, taken place from 2023 to 2025.
Correct.
So that is, if we're using 3 years, around 36 evaluations.
Sure.
These
I'm not great at math.
These evaluations noted Max as being highly controllable,
That's right.
as having strong obedience,
That's right.
as being steady around kids.
Yeah, these evaluations say that.
These evaluations of Max said that he's highly controllable,
That's right.
has strong obedience,
Yeah, these ones do.
yes, and steady around kids.
Correct.
You would have taken this as well as other documents into consideration during your investigation.
Yes, as well as other documents.
And at the end of your investigation, you submitted a final findings email.
Yes,
If you saw this email, you would recognize it today.
I would.
referring court and counsel to what has been pre-admitted as Exhibit 3. Actually, it's already been admitted, so I will be not doing the counsel log.
Understood?
Exhibit 3 is your final findings email.
Yes.
In this final findings, you collaborated with the board to reach these final findings.
Yes.
Ultimately, the board found that different factors did not materially alter the reasonableness of Max's response.
Correct.
And these factors were Officer Davis loosening his leash.
Right.
It was Max's 2 previously undocumented by incidents,
Sure.
as well as the confined space of the bus.
That's right.
And ultimately, the board found this deployment was reasonable.
That's right.
No further questions, Your Honor.
Thank you, Ms. Martinez. Ms. Shergill, I'm pronouncing that correctly, right?
Yes, you are.
Shergill, okay.
Yeah, you're good.
Just want to make sure I'm doing that. You have about 20 seconds for a redirect. If you want to do one. You're not required to do one.
I can do one.
When you're ready.
Mr. Alvarez, did these policies and trainings take into account the conduct of a canine around minors specifically?
Not necessarily.
No further questions, Your Honor.
Thank you. All right, and that concludes the defense case in chief, is that correct? There's no further witnesses?
Yes, Your Honor.
And my understanding is that plaintiff will be giving a closing argument, defense will not be giving a closing argument, correct?
Yes, Your Honor.
Okay, well then, now that the parties have rested, let's proceed with closing argument on behalf of the plaintiff.
Yes.
Again, please look towards Mr. Allen, who will be
The timer?
providing you with your time. Yes.
Thank you. Silence over safety. That is what happened in this case today. This case did not begin on that school bus. This case began years prior, when the city of Blue Note was first made aware that Max was dangerous around children and chose to do nothing. You didn't hear this story from me. You heard it from Monica Alvarez and the city's municipal employees. Monica Alvarez testified that in her role as senior investigator, her job was to conduct reviews of incidences, track warnings, and recommend change. Officer Davis has admitted that Max has bitten children in the past. Nothing's changed. These incidences were not always reported, and Officer Davis admitted that on October 25th, 2025, Officer Davis loosened his leash on Max, and Max held on longer than training allows. There is no question that Officer Davis was acting under legal authority. After all, he is a city police officer conducting a city-approved school bus sweep using a city-trained K-9 unit. The law asks whether a reasonable officer believes that the force he used was reasonable. A reasonable officer does not introduce an attack-trained K-9 unit onto a school bus full of children, knowing that that K-9 has bitten children before with no safeguards in place. The city of Blue Note had no such safeguards. No policy requiring the reassessment of a K-9 after incidences involving minors, no policy for regulating the conduct of a K-9 around minors, no policy for confined spaces, and a practice of not reporting to the state registry. When a city repeatedly fails to act on known dangers, that is their policy. Monica Alvarez was consistent. She emailed command staff, tried to implement some change, and instead of listening to her, she was silenced. She was fired for trying to do something. Because there was no reassessment policy, Max continued to be deployed. Because there was a practice of not reporting to the state, there was no oversight, and because there was no policy for children or confined spaces, Max was placed in the exact environment he was most dangerous in. That is not merely negligence, that is deliberate indifference. The city would like you to believe that this was caused by Nat's sudden movement. Sudden movement from a child is not unforeseeable. It is to be expected. And the law does not excuse excessive force because a child acted like a child. Nat Cole pays the price. 6 stitches, deep puncture wounds, pain, fear, trauma, with scars for the rest of his life. An innocent 13-year-old for something he didn't do. The city would like you to believe that Max was highly controllable, yet listed the factors in the very report they showed. Loose leash, prior incidences with minors, no retraining, no policy, yet highly controllable. That is not reasonable. Opposing counsel mentioned reasonableness a lot. Reasonableness in the way that they wanted to conduct a school bus sweep. That school bus sweep didn't have to happen with Max, the canine. Monica Alvarez tried to warn them, tried to get them not to use Max, the canine. But instead of adhering to their own employees, they continued to listen to what was just regulations and state regulations. The city kept asking whether Max passed training and certification on paper, never asked whether Max belonged on a school bus full of children. We ask you, members of the jury, to return a verdict in favor of Nat Cole and hold the city of Blue Note accountable for their lack of policy and lack of accountability. Thank you.
Thank you, Ms. Sugar. The prosecution now rests. Excellent job, both of you. I want to thank you both for your time, your preparation, for your performances here today. It's a testament of the hard work that the both of you put in, but also the love and support from your friends and family who are here supporting you all today. Again, very nicely done. We won't be giving individual comments or feedback, but I do want to encourage you both to come to the reception tonight. It's going to be here in the courtroom from 5:15 to 6 p.m. It's going to be at that time that we announce the award winners. Just again, a very fantastic job. So I hope to see you in a couple hours. All right.
Thank you.
And congrats once again for making it to the finals.
Thank you. Sure.
Oh, sure.
Yeah. Should we get in the front?
Wherever works. I just have to be far away, sorry.
Okay.
Perfect.
Thank you. That's fun. Let me clear these out of the way.
And if you both haven't already done so, and if you're interested, we would love to have you come participate at the NTC competition. It's the weekend of February 20th through the 22nd. If you're interested in serving as a bailiff or a witness, both of you would do absolutely fantastic. There's a link that we're going to be sending out again tonight. But just consider it.
Will do, sir. Thank you.
Okay, I'm trying to get to yours if it's not.
Just one. Because they're a little out of order in the box here.
Rhonda, do you have a second copy up there of Exhibit 11?
I probably do. Give me 1 second.
In the witness area. Because I think we don't
Anyone itching to come up here?
You're just doing such a good job that I just don't think there's a world where.
Tyler?
Very fitting.
I just want to open up the opportunity in case, not that I, am trying to shirk my duties, but in case anybody wants to, just know that you're obviously welcome. No, that's why.
Yes. It's this in the corner. You can take it. I only need a copy of this in the corner. I have a double copy of this. What do you want?
Can you scoot the microphone
Like if you
forward?
had 2 years in the that's why it's a good idea.
Oh, it doesn't move, it's like in place?
No, it's like in there.
Okay, so here's what I'm gonna ask you to do. I'm gonna ask you just to kind of lean in on the microphone. I don't want it to like ruin your performance.
Yeah, because I want to go over there.
Oh, okay, then that's fine. You know what? I wish I had a microphone for you. And I'm gonna ask you both to do this again when we officially start. We've got about 10 minutes, but just for my own. For the jurors, this is round 3, and we'll start again, just re-announcing our appearances. Are we ready to proceed?
Yes, Your Honor.
Yes? Okay. Calling the case of Nat Cole versus the City of Blue Note. If we can start with appearances from Plaintiff's Counsel, please.
Good morning, Your Honor. My name is Nora Ruvalcaba on behalf of the plaintiff, Nat Cole.
And Ms. Ruvalcaba, can you remind the court what portions of the trial you will be performing today?
Of course, Your Honor. I will be performing an open and a cross of Officer Davis.
Thank you so much. And appearances for the defense.
Good morning, Your Honor. My name is Natalie Mendes. I'm representing the defense in this matter, the City of Blue Note, and I will be doing the direct of James Johnson and a closing statement.
And just for our jurors, Ms. Mendes advised me before trial proceeded that she's unfortunately lost her voice, so she's going to do her best to project. And so if she needs to use the podium, please don't count that against her. All right, are we ready to proceed?
Yes.
Yes? Okay, plaintiff has an opening statement, defense does not, is that correct?
Yes, Your Honor.
Okay, we'll start with you, Ms. Ruvalcaba.
Your Honor, permission to enter the well?
You may, yes. And Mr. Allen, for both of you, Mr. Allen, who's in the back left corner, is going to be doing double duty today as your timer during your statements, as well as playing your witness. So please look at him during your opening and closing for your 1 minute mark and then time. Understood? When you're ready, please proceed.
Tick, tick, tick. Like a ticking time bomb, it was only a matter of time before the City of Blue Note's canine bit another child. 2022, 2023, 2024, and finally, the reason you sit here today, October 25th, 2025. These dates tell a single story. What happened to Nat Cole was not an accident, it was a pattern. And patterns create predictability, and predictable harm can be prevented. This case is about 3 simple truths: a pattern of dangerous canine behavior, the predictability of what was to come if these signs were ignored, and the prevention that never came. Each year, the City of Blue Note had a chance to act, and each year it chose not to. It was October 25th, 2025. Nat Cole, along with all of his classmates, were headed to school on the school bus. The evidence will show you that this was an average day, and that these children had no idea what was coming. You will see that Officer Davis and his canine unit get onto the bus that day, and that contrary to police policy, Officer Davis loosens his grip on his canine's leash. As a result, Nat Cole was bit. You're going to hear a lot of evidence today that spans over a couple of years. But first, we're going to talk about patterns. Patterns that the city chose to ignore. Then, we're going to talk about the predictability of those patterns. You will hear from Monica Alvarez and how she warned the city of the canine's behavior. And finally, we will talk about how the city chose inaction rather than prevention. Starting with patterns. A pattern is what happens when the same risk is ignored again, and again, and again. The evidence will show that the city's canine had a long and documented history of aggressive behavior. You will see that this canine was particularly sensitive to confined spaces and environments with children. You will see a copy of this canine's report, and it documents 3 prior incidents while on duty. In 2022, this canine bit a child during a school safety demonstration. In 2023, once again, this canine bit a different child during a routine traffic stop. And in 2024, to nobody's surprise, this canine had an outburst and lunged at another unit on duty during a holiday parade. 2022, 2023, 2024. Similar setting, same dog, same risk. A ticking time bomb. You will hear from Monica Alvarez, a former senior investigator with the city. She will testify that she warned the city of this canine's predictable pattern of behavior. You will see that just 5 days before October 25th, on October 20th, Ms. Alvarez emailed the city warning that the canine should not be deployed in the upcoming school sweep. She will testify that the canine was a predictable risk to children. The result? Predictable. Nat Cole, a middle school boy just trying to get to school, was bit by the city's canine. The canine bit Nat so hard he had deep punctured wounds. Nat Cole had to go to the hospital. He required 6 stitches. This is the exact type of harm Ms. Alvarez predicted. You will see that the city had every opportunity to prevent the harm. However, it never implemented formal policies related to its canine deployments in school environments. It left officers to rely on their own informal understandings and practices. It left safety to chance. At the end of this trial, my co-counsel and I will have proven by preponderance of the evidence that Officer Davis acted under legal authority and used excessive force no reasonable officer would have deemed necessary, and that this was not in isolation. The evidence will show you that the city of Blue Note maintained dangerous practices regarding its canine deployments, and that was the force behind it all. Pattern, predictability, prevention, deny. 2022, 2023, 2024, and finally, October 25th, 2025. Tick, tick, boom. On behalf of Nat Cole, an injured middle schooler, we ask you to find the city liable. Thank you.
Thank you, Ms. Rubalcaba. Given that the plaintiff will not be giving a direct examination today, we're going to forego the plaintiff's case in chief, which is atypical for a case, and we'll move directly into the defense case in chief. Ms. Mendez, if you could call your first witness to the stand, please.
Your Honor, the defense calls James Johnson to the stand at this time. May I proceed?
You may.
Hello, please state your name for the court.
Hi, my name is James Johnson.
And how old are you?
I'm 13 years old.
All right. Let's start with Nat Cole. How do you know Nat Cole?
We're classmates at the Notebook Middle School together. Yeah, we go to school together.
Okay. Can you tell the jury a little bit about Nat's personality at school?
He's not really kind to me.
Objection, Your Honor. Propensity as to the witness's answer.
Can you elaborate?
Of course, Your Honor. Your Honor, the witness is testifying to a prior character trait of Nat Cole, and that's not admissible under propensity. It's not fair to say that just because Nat Cole was reactive or a little bit out there in class, that means he acted in the same way on October 25th, 2025. This was a very different environment, therefore this falls under propensity.
Ms. Mendez, can you remind me what the question was specifically?
I asked him to remind the jury about his personality at school.
Whose personality?
Nat Cole's.
Can you give me an offer of proof of what the witness will testify to?
We are just trying to prove that Nat Cole has knowledge that he must listen to adults the first time.
Do you have a response to Ms. Rubalcaba's objection that this testimony qualifies as propensity evidence?
We are just trying to prove that Nat Cole has the knowledge that he must listen to adults the first time instructions are given.
Understood. Ms. Rubalcaba, I'll give you the final word if you have any additional argument.
Yes, Your Honor. Your Honor, then I would move my objection to relevance, as James Johnson is testifying to things that happened before October 25th, 2025, and he is not Nat Cole. Therefore, his understanding of Nat Cole's understanding is not relevant.
Your objection is very well taken, but I'm going to overrule at this time. Please proceed.
So if you may, please tell the jury about Nat Cole's personality at school.
Yeah, he's not really a kind kid. He likes to push limits. He jokes around with me a lot. He makes fun of the way that I dress and the way that I talk.
And does he listen to instructions on the first time they are given?
No, adults and teachers typically have to tell him more than once to do things.
Let's move on to the incident on October 25th, 2025. Were you on the bus that day?
I was.
Was Nat Cole on the bus that day?
Yeah, he was, but we weren't sitting together. We don't like each other.
Were you able to see his seat from where you were seated?
Yes.
Let's move on to Officer Davis. What did Officer Davis do when he first boarded the bus?
He told everybody to keep their hands on their laps and not to make any movements.
Did he remind you anything about the dog?
He said not to pet the dog, that's right.
And did Nat Cole listen to those instructions?
Not from how I saw it. I saw Nat make a movement towards the dog.
All right. Let's move on to social media. Do you have any social media platforms?
Yeah, I have Facebook.
And what do you do on Facebook?
I look at posts. I'm just 13 years old. I look at memes, and I have some friends on there, and I see what they post.
So you post pictures, comments.
Yeah, I would do, just the regular stuff.
Would you recognize one of your Facebook posts if I showed it to you?
I would.
Your Honor, permission to approach the witness with Exhibit 8, which has been pre-marked and pre-admitted for trial.
You may, but please show it to opposing counsel first.
Showing to opposing counsel. Approaching the witness. And what have I handed to you?
So this is a Facebook post. It's Nat Cole's Facebook post, and then I made a comment to it.
And is this a fair and accurate representation of your Facebook post?
Yes.
Your Honor, permission to publish to the jury.
You may.
So the Facebook post is a post between you and Nat Cole?
That's right.
And what did Nat Cole post?
He said, "I can't believe I got bit."
And what did you reply to that?
I said, "Well, what did you expect? You moved."
And what did Nat Cole reply to that?
LOL, don't tell my mom.
So he said, "Don't tell my mom."
That's right.
No further questions, Your Honor. Permission to gather the exhibits.
You may.
Thank you.
And my understanding is there is no cross-examination of this particular witness, but there is a cross-examination of another witness. Is that right?
Yes, Your Honor.
Okay. And which witness will you be cross-examining?
Officer Davis.
Okay. So now Officer Davis. Thank you, Ms. Mendes. Ms. Rubalcaba, please proceed when you are ready.
Good morning, Officer Davis.
Good morning.
I'm going to start by asking questions about your professional career. You've been a police officer for 10 years, correct?
That's right.
You're currently assigned to the K-9 unit,
Yes, since 2021.
and you're partnered with the 6-year-old German Shepherd, right?
Max, that's right.
And before 2025, the city didn't implement any policies related to K-9 deployments in school environments, right?
No official policy, it was all verbal.
And you'd recognize a copy of your K-9's report, correct?
Yes.
Referring court and counsel to what has been previously marked and entered as Exhibit 1, let the record reflect I am now showing opposing counsel what has been marked as Exhibit 1. Your Honor, may I approach the witness?
You may.
Officer Davis, directing your attention to this report, this is a copy of your K-9's behavior report, correct?
Yes.
It's a fair and accurate copy,
Yes, I had a hand in making these reports.
and it hasn't been altered in any way, correct?
Absolutely not, that's right.
So by 2025, your K-9 had a documented history of aggressive behavior, right?
And I'm sorry, can I interrupt? Is this document pre-admitted?
Yes,
Please proceed.
I'm sorry, could you repeat the question?
of course, Officer Davis. By 2025, your K-9 had a documented history of aggressive behavior, right?
Yes.
Let's walk through those instances. In 2022, your K-9 bit a child during a school safety demonstration, right?
That's right.
Objection, Your Honor. Relevance.
Can you elaborate for me?
Just that the incidents from 2022 aren't relevant to the incident that happened on October 2025.
Response?
Of course, Your Honor. These are relevant as they're foundational to the basis of the Monell claim, knowing that the city was aware of this K-9's lack of training in these types of combined conditions, and that the city didn't implement any policies post these incidents, which is proof that the city directly violated the Monell claim.
And remind me the date of this particular incident
2022,
and the date of our incident underlying this case.
2025.
I'll give you the final word, Ms. Mendes.
Yes, I would just like to say that it's 3 years later. It's a different incident, and it shouldn't be used to further bolster this incident at our case.
Understood. Your objection's well taken, but it will be overruled at this time. Please proceed.
Officer Davis, in 2022, your K-9 bit a child, right?
Right.
And the city didn't implement any policies after this, correct?
Not to my knowledge.
In 2023, once again, your K-9 bit a child during a traffic stop, right?
He made brief contact with the team passenger.
And again, the city didn't implement any policies after this.
No formal policy.
And in 2024, your K-9 lunged at another K-9, correct?
That's right.
And the city didn't implement any policies after this.
No formal policy.
Officer Davis, you'd recognize a photo of your K-9, wouldn't you?
Yes.
Referring court and counsel to what has been marked and entered as Exhibit 11, let the record reflect that I am showing opposing counsel what has been marked and entered as Exhibit 11. Your Honor, may I approach the witness?
You may.
Officer Davis, I'd like to direct your attention to this photograph. This is a photo of your K-9, right?
Yes.
It's a fair and accurate photo,
Yes.
and it hasn't been altered in any way.
No.
Your Honor, permission to publish to the jury?
You may.
Now, Officer Davis, this is a photo of your canine reacting to a child, right?
So this is, that's right, yes.
May I retrieve the exhibits, Your Honor? Now, Officer Davis, I'm going to ask you some questions about October 25th, the day your canine bit Nat Cole. You were conducting a sweep of a school bus that day, right?
Correct.
It was really early in the morning, correct?
Sure.
And there were a bunch of kids on the bus, right?
Yes,
It was crowded,
I would say so.
and there were backpacks on the floor.
There were.
And Officer Davis, you're aware that these types of environments can make your canine more reactive, right?
Sure.
Yet you allowed your canine on the bus that day, didn't you?
As part of our operation, yes.
And Nat Cole was also on the bus, right?
Yes,
He was sitting in like the middle of the bus.
around
Right.
there.
He also had his backpack at his feet, correct?
That's right.
And you admit that at some point you loosened your grip on your canine's leash, right?
I did, yes.
And moments after that, your canine lunged at Nat Cole. Isn't that correct?
Yes, but it's not because I loosened my grip on the leash.
But Officer Davis, your canine didn't just lunge at Nat Cole. Your canine actually bit Nat Cole, right?
Unfortunately, yes.
And Nat Cole had to go to the hospital.
Unfortunately, yes.
And you're aware now that actually Nat Cole needed 6 stitches, right?
I'm now aware of that, yes.
And Officer Davis, you were looking for drugs that day, weren't you?
Yes.
But you didn't find any drugs, did you?
No, I did not find any drugs.
And you didn't find any drugs on Nat Cole either, right?
No.
Thank you. No further questions, Your Honor.
Thank you. Ms. Mendez, you do have a minute if you would like to do a redirect. I'll give you the opportunity. You're not required to do one, but if you would like to do one, you do have time.
I'm okay, thank you.
Okay, thank you. And we have no further witnesses, is that correct?
Yes, Your Honor.
Okay. My understanding is that the plaintiff is foregoing their closing argument, correct?
Yes, Your Honor.
All right, Ms. Mendez, the floor is yours when you're ready.
Permission to approach, Your Honor.
Okay. And again, please look at Mr. Allen on your back left corner for your time.
One moment, one choice. Members of the jury, today I have proven to you that the instant decision of Nat Cole has caused the incident we are speaking of today. I have further proven that the explicit safety commands of stay seated, keep your hands to yourselves, and do not pet the dog were given to the entire bus by Officer Davis. This was to ensure a speedy school bus sweep and the safety of all students on the bus. Nat Cole was bit by Max because Max reacted to the sudden downward movement made by Nat. No other children on the bus were injured because no other children moved towards the dog. Nat moved, Max reacted. One moment, one choice. The plaintiff has the burden of proof in today's trial and must prove by a preponderance of evidence all 6 of their elements that it is more likely than not that the defense is liable. They fail. We know this for 3 reasons. 1, Nat moved. 2, Nat failed to follow the safety instructions. And 3, most importantly, he admits it. Moving on to point number 1, Nat moved. Testimonies from James Johnson further proves that Nat made a sudden downward movement was made by Nat, carelessly disregarding the safety command given to the entire bus of stay seated, keep your hands to yourselves, and do not pet the dog. Our second point was over here by James Johnson, and James Johnson testified that Nat failed to follow the safety commands, that he tests limits, pushes boundaries, and fails to listen to safety instructions the first time they are given. Those instructions of stay seated, keep your hands to yourselves, and do not pet the dog. Our third and final point in today's trial is that he admits it. In the Facebook post of a thread between Nat and James Johnson, It further proves the behavior that Nat is prevalent to have. That Nat posted, "I can't believe I just got bit," with James replying, "Well, what did you expect? You moved." With Nat replying, "LOL, don't tell my mom." Nat knew he had done something wrong. He did not want you to tell his mom. Don't tell my mom. Nat has done something wrong. Nat knows he has done something wrong. He has disregarded the safety instructions and is facing the consequences of his actions. One moment, one choice. As members of the defense representing the city of Blue Note, we sympathize with Nat as he has been bit in the arm. However, we also recognize that actions have consequences. We must not let our feelings cause us to disregard the fact that Nat's own actions caused his injuries. All because Nat wants to test limits, push boundaries, and fails to listen to instructions the first time they are given. Those instructions of stay seated, keep your hands to yourselves, and do not pet the dog. And furthermore, he admits it. His actions, he is facing consequences of his actions. One moment, one choice. Today, the members of the defense ask you find a verdict that aligns with logic and evidence in today's trial, that the city of Blue Note is not liable.
Congratulations to both of you. That's the end of our round, so once again, round of applause. I want to congratulate you first and foremost for making it to the final rounds. Excellently done, both of you, and I want to thank your friends and family in the back for coming and supporting you. Very nicely done. As a reminder, we have the reception and the announcement of our top 3 winners and individual awards tonight here in the courtroom from 5:15 to 6 p.m. So I hope to see you both there. And otherwise, again, fantastic job. Just a testament to the hard work and preparation that you put into this. So one more round of applause. And as a reminder, if you haven't signed up to serve as a bailiff or a witness for the National Trial Competition the weekend of February 20th through the 22nd, we would love to have both of you. Excellent.
Did you take exhibit 12 from your card today? Your extra copy? Oh, that's well, you see if your extra copy has it. I just, for the next round, I want it to be easier for them.
round 4.
This is round 4.
Are we ready?
Let's do it.
Council, are we ready to proceed? Yes. Okay. Calling the case of Nat Cole versus the City of Blue Note. I'd like to start with appearances from the parties, starting with plaintiff's counsel.
Roxanne Wright, attorney for the plaintiff Nat Cole.
And Wright spelled how?
W-R-I-G-H-T.
And appearances from the defense.
Good morning, Your Honor. I too represent the plaintiff in this case, Nathan Cole. My name is Elizabeth Monteroso.
You spell Monteroso for me?
Monterroso.
Miss Wright, Miss Monteroso. Okay. Just a friendly reminder, we have 2 plaintiffs in this round. So Miss Wright will be considered advocate 1 for scoring purposes. Miss Monteroso will be considered advocate 2 for scoring purposes. Okay?
And what are they planning on?
Yeah.
Okay.
Thank you for the reminder. Miss Wright, what portions of the trial will you be performing today?
I will be doing the direct of Monica Alvarez and the closing.
Okay. Miss Monteroso?
I will be doing the opening and the cross-ex.
Oh, very nice. So we'll get a full plaintiff case then.
I'm sorry, can I get the witness names for
Yes.
purposes?
One more time, who are you directing?
Monica Alvarez.
And who are you crossing?
I'll be directing Police Officer Davis.
Oh, I'm so sorry. So,
Cross-examining.
okay, there you go. So cross of the officer, direct of Miss Alvarez. Thank you.
Okay, good. That's for me. Good. Excellent. Thank you.
Okay, are we good? Okay, let's start with opening statement from the plaintiff. Obviously, we have 2 plaintiff's attorneys here. So, Miss Monteroso, you will be giving the plaintiff opening.
Yes.
All right. Proceed when you're ready. Please, for both of you, look to Mr. Allen in your back left corner for your time during your openings and closings, and then look to me for your time during your cross and direct, okay? When you're ready. And there's a podium here if either of you need to use it at any point.
Failure to assess the risk. Failure to prevent the preventable. Members of the jury, today you will learn that on October 25th, the City of Blue Note authorized a school bus drug sweep where scared 13-year-old boy Nathan Cole was injured after the city believed it was necessary to deploy a canine into a bus full of children. And they didn't deploy any canine. No. The city deployed Mad Max, who you will learn today had a history, a dangerous history, especially around children. Today, you will learn that this was not an unforeseen tragedy. No. The city was aware of Max's incidents, and yet you will learn that they failed to provide an updated risk assessment. They failed to prevent the preventable. In 2021, the Blue Note Police Department received Max as an addition to their team. During his time with the department, Max has only had 1 certified handler, Officer Davis. And for the following years, Officer Davis' license was renewed. Yet you will learn that the City of Blue Note did not require independent temperament evaluations. The city did not require a determination of whether Max, or any dog for that matter, was qualified for field missions. No, because the city deployed Max. The evidence will provide that Max has been involved in violent incidents year after year. Once in 2021, where Max was taken to a school assembly, and at the scream of a child, Max bit a student. Once in 2022, where Max was conducting a regular traffic stop, and without provocation, Max bit that minor, leading to a $12,500 settlement. Once in 2024, where Max was taken to a holiday parade and where he lunged towards his fellow canine. And that leads us to today. On the morning of October 25th, Nathan Cole was on his way to school when Officer Davis and Max entered the bus. You will learn that as Max got closer, Nathan could not help but look around or switch his body posture. And who could blame him? You will learn that in such a confined space, Officer Davis violated his policy and he loosened his grip over Max, and you will learn that as a result, Nathan Cole was bitten and he suffered deep puncture wounds as a result of Officer Davis, Max, and the City of Blue Note's negligence. The city had the opportunity to assess Max's capability. However, because they did not, we, on behalf of the plaintiff, bring a Monell claim against the City of Blue Note. We bear the burden of proof by preponderance of the evidence, and the evidence will provide that it is more likely than not that 1, Mr. Davis was acting within his municipal police duties, that 2, excessive force was used, that 3, Mr. Davis' custom of taking Max without an updated assessment created risk, that 4, the city knew the risk of allowing Max onto that bus, that 5, the city's lack of assessment in missions with confined spaces and minors caused the injury, and that 6, Nathan Cole was in fact injured. So when you look at your verdict form, we ask you to find that the city was negligent and that they did have deliberate indifference. Today, you have the opportunity to transform a narrative of failure into one of future protections. And I trust that you will make the right decision.
Thank you, Ms. Monterosso. Let's proceed with the plaintiff case in chief. Ms. Wright, that's your direct examination, correct?
Yes,
Please call your first witness.
The plaintiff is calling Monica Alvarez to the stand.
Yes.
And it's Roxanne Wright, right?
Yes.
I am Monica.
Good morning.
Good morning.
Can you please state your name for the court?
Yes, my name is Monica Alvarez.
Can you please spell your last name?
Alvarez.
Mr. Alvarez, I'm going to ask you a couple of questions about the Nat Cole incident and your role at the Blue Note Police Department. Is that okay with you?
Yes.
Permission to enter the well?
You may.
Mr. Alvarez, what was your role at the Blue Note Police Department?
Right, so I was an investigator with the Public Safety Critical Incident Review Board.
And what exactly did you do within that role?
So I reviewed use of force incidents with our police officers, the deployment of canines, and supervised and looked at trainings and policies.
And how long did you work with the Blue Note Police Department?
From 2021 until 2025.
Do you currently work with the Blue Note Police Department?
Unfortunately not, I was laid off.
Why were you laid off?
Well, I believe it's because of my, let's put it this way, advocacy for a change in policy, which they did not like.
Mr. Alvarez, if I were to show you a series of incident reports about Max, would you recognize that?
Yes.
I am showing opposing counsel what has been pre-admitted into evidence as Exhibit 1. Permission to approach the witness?
You may.
Mr. Alvarez, I just handed you Exhibit 1. Can you please describe that for me?
Yes, so this is a canine incident report regarding a canine by the name of Max, whose handler is Officer Davis.
How many incidents occurred concerning Max prior to the Nat Cole incident?
3.
And how many of those were by incidents?
2.
Were all of these by incidents reported to the canine registry?
I don't believe so.
Was that a standard practice for the police department not to report these kinds of incidents?
It was an unspoken practice not to do it, yes.
Mr. Alvarez, based on what you know, how would you describe Max's behavior?
He is not he's very temperamental around minors, so in other words, kids. I would not recommend him to be in the presence of school children.
Thank you, Mr. Alvarez. If I were to show you an email that you sent to the police department, would you recognize that?
Yes.
I'm showing opposing counsel what has been entered into evidence as Exhibit 5. Permission to approach the witness?
You may.
Mr. Alvarez, I'm showing you Exhibit 5. Can you please describe this for me?
Yeah, this is an email that I sent to Lieutenant Whitlock of the Blue Note Police Department, CCing Officer Davis regarding Officer Davis's K-9 Max and Max's temperament assessments.
And why exactly did you write this email?
Because I believe that Max was not a suitable K-9 for an environment with children in it.
Can you please read the highlighted line on that paper for me?
Right, so based on Max's temperament assessments and his sensitivity to sudden movement, I believe Max is not a suitable K-9 for a child environment. The combination of tight aisles, backpacks on the floor, and unpredictable juvenile behavior presents a foreseeable risk of unintended contact.
And Mr. Alvarez, when you say unpredictable juvenile behavior, what do you mean by that?
Well, I mean, we all know kids, to no fault of their own, they're a little bit, shaky,
Right.
especially around authority figures.
Is this the only time that you reported your concerns to the Blue Note Police Department?
No, I can't tell you the specific number of times, but it was more than just this occasion.
And did the department ever come up with any sort of policy regarding K-9s after you reported your concerns?
No, I think, and forgive the brash term, I think they blew me off.
Right. And did they ever do anything concerning your concerns?
Absolutely not. Well, they fired me, actually.
Right. Mr. Alvarez, if I were to show you another email that you sent to the police department, would you recognize that?
Yes, probably.
I'm showing opposing counsel what has been pre-admitted into evidence as Exhibit 3. Permission to approach the witness?
You may. 1 minute remaining.
I just handed you Exhibit 3, Mr. Alvarez. Can you please describe that for me?
Yeah, this is an email from the Internal Review Board regarding the K-9 incident regarding Max and Nat Cole.
Can you please read the highlighted line on that paper for me?
The board concludes that these issues did not materially alter the reasonableness of Max's response in this specific situation.
And why exactly did the board conclude that Max's response was reasonable?
They didn't really have a written policy at the time, and I think that they're just trying to cover their bases.
And then why was Nat Cole injured?
Because of, to me, the handling officer's inability to handle his own K-9 as well as the K-9's temperament with children.
And finally, Mr. Alvarez, do you believe that this incident could have been avoided?
Yeah, if they listened to me.
Thank you, Mr. Alvarez. That's all.
Perfectly 5 minutes. Thank you, Ms. Wright. We have a cross-examination on behalf of the plaintiff from Ms. Monteroso, but of a different witness, correct?
Yes, Your Honor. The plaintiff calls Officer Davis to the stand.
And Officer Davis is at the stand, and now please proceed with your cross-examination.
Okay, yes or no?
Good morning, Officer Davis.
Good morning.
Let's talk about Max, your K-9. You've been his handler since 2021?
Yes,
So if I showed you a copy of his training records, would you be able to recognize that document?
absolutely.
Referring court and counsel to what has been pre-admitted as exhibit number 12. Let the record reflect that I am showing opposing counsel. Your Honor, permission to approach the witness with the same?
You may. And I'm sorry, has this been pre-admitted?
Yes.
Yes, thank you.
Mr. Davis, you recognize this document?
I do.
You recognize this because you are Max's sole handler?
That's right.
This is a fair and accurate copy of Max's training records?
It is.
This is the same or substantially similar to the last time you saw it?
Should be.
Let's go down to bullet point number 5. It states that Max has completed more than 16 hours per year in schools, buses, and crowded settings where he was noted as calm and controlled. Did I read that correctly?
Yeah, you read that wonderfully.
It also mentions that the supervisor notes him as consistently positive, where he is highly controllable, strongly obedient, and steady around kids, yes?
Yes.
But there were also 2 training bites which were not submitted due to administrative oversight, yes?
Sure. I know that there were bites.
But there was no aggression pattern found, right?
That's right.
And you agree with all of this?
Yes.
But let's talk about those incidents then, Officer Davis. If I were to show you a copy of Max's canine report, would you recognize that document?
Yes.
Referring court and counsel to what has been pre-admitted as exhibit number 1. Let the record reflect that I am showing opposing counsel. Your Honor, permission to approach the witness with the same? You may. Officer Davis, you recognize this document?
Yes.
And you recognize this because you were present in each of these incidents?
Correct.
This is a fair and accurate copy of Max's canine report?
Yes.
This is the same or substantially similar to the last time you saw it?
Yes.
Let's talk about the incident March 2022. Max bit a student, correct?
That's right.
And the summary states that during a school safety demonstration, Max bit the student after the handler, Officer Davis, you, failed to maintain proper control. Is that correct?
That's right. It's my fault on that one.
This also mentions that Max completed corrective retraining, right?
Sure.
Yet 1 year later, Max was involved in a traffic incident?
Sure.
Is it yes?
Yes.
Officer Davis, this also states that Max made contact with a minor in that traffic incident?
That's right.
And then 1 year later, after Max lunged towards another canine, the actions taken states that a supervising sergeant filed a memo recommending Max be removed from public assignments. Did I read that correctly?
Yes.
Yet that was not the only recommendation you received about Max, isn't it? You received an email from the Critical Incident Review Board?
Sure. Yes.
And if I showed you a copy of that email, would you be able to recognize it?
I should be able to.
Referring court and counsel to what has been pre-admitted as exhibit number 5. Let the record reflect that I am showing opposing counsel. Your Honor, permission to approach the witness with the same?
And I believe you said it's pre-admitted, correct?
Yes. Mr. Davis, you recognize this email?
Yes, I was carbon copied on it.
Yes, and just to confirm, that is your email on the CC line?
Yes.
This is a fair and accurate copy of that email?
Yes.
This is the same or substantially similar to the last time you saw it?
Sure. Yes.
Thank you, Officer Davis. Just to confirm, this email is dated October 20th, 2025?
Yes.
That is 5 days before the bus incident?
Yes.
And the context of this email specifically states the combination of tight aisles, backpacks on the floor, and unpredictable juvenile behavior presents a foreseeable risk of unintended contact. Did I read that correctly? 1 minute.
Sure. Yes.
Yet 5 days later, you took Max onto that bus, did you not?
I did.
And the city authorized you to deploy him onto that bus, did it?
Well, the city and the school.
Thank you, Officer Davis. Let's talk about what happened on that bus. Would you categorize the environment of the bus as confined?
Yes.
So that means that policy stated that you were required heightened leash control?
Yes.
Yet you heard Max bark, didn't you?
That's part of his training, is to bark when he detects drugs or drug residue.
And you loosened your grip over his leash?
Yes.
This was right before Max bit Nathan Cole, was it not?
It was.
Mr. Davis, Max has an average time, according to his records, an average release time of 1.2 seconds. Is that correct?
That's right, and it's Officer Davis.
Time.
Could I ask one final question?
Sure, one final.
Mr. Davis, could I ask you if it was absolutely necessary to have Max on that bus with those children?
Yes, it was, to detect the drugs.
It's your time.
Thank you.
Thank you. Okay. Plaintiff, you rest your case in chief, correct? No more witnesses? Okay. Let's proceed to closing argument, and that would be you, Ms. Wright. Correct. Again, please look at Mr. Allen on the left hand corner for your time. And proceed when you're ready.
Foreseeable, preventable, and permanent. Members of the jury, today you heard the story of Nat Cole, a young, innocent boy whose injuries were foreseeable, preventable, and permanent. Nat now lives with scars and trauma due to the carelessness of the Blue Note Police Department. The story you heard today could have been entirely different, entirely avoided, had the Blue Note Police Department done their due diligence. Members of the jury, it was my job today to prove to you all 6 elements of a Monell claim. A Monell claim simply states that a civil action can be brought against a government agency for the violation of civil rights. The first element of a Monell claim is that there was the agency acting within its legal authority. That is undisputed. We all know that. We can all agree that Officer Davis was acting within the legal authority of the Blue Note Police Department when he brought Max onto that bus. The 6th element of a Monell claim is that an injury occurred. Again, this is undisputed. We all know that. We can all see that Nat Cole has suffered an injury due to the situation of which we are currently disputing. The final 4 elements of a Monell claim are that there was a policy that was the moving force behind the violation, that there was an indifference by the agency to the risk of injury, that there was an excessive force used, and that there was an inaction by the agency regarding the risk of injury. Members of the jury, based on all of the evidence that I have presented to you, I have proven all of these elements. As you heard, the police department knew of Max's behaviors. They knew of the risks that were associated with it, and they took them anyways. They knew of the risks that were associated with putting Max onto that school bus surrounded by children, and they continued on. No child or dog should be placed into that situation. No dog with a history of violent, reactive behavior should be placed there. Max was, and Nat Cole has suffered because of it. The police department knew that this use of force was excessive. They knew of the risks associated with it, and they continued on. They knew of their lack of policy and chose not to create one. As you heard, Officer Davis and Monica Alvarez spoke of Max's behaviors, his history, and the police department's policies, or their lack thereof. You heard my opponents today attempt to put the blame on Nat Cole, a young, innocent boy who was failed by the very people designed to protect him. Members of the jury, based on all of the evidence that I have presented to you today, I am asking you to find Blue Note entirely liable. It was and continues to be a danger to us and our children to allow police departments to get away with this flagrant ignorance, lack of policy, causing foreseeable, preventable, and permanent harm. Thank you.
Thank you, Ms. Wright. And that concludes our trial today. Congratulations. Congratulations to both of you. We all want to thank you on behalf of the McGeorge Trial Association and Mock Trial Program. Congratulations for making it to the finals, and thank you so much for your preparation, for your performance today, and for our friends and family who are supporting in the back. Thank you for coming and joining us. I want to remind you that there is a reception tonight right here in the courtroom from 5:15 to 6 p.m. Where we will be announcing our top 3 advocates as well as all the individual awards. So love to see you, both of you there. Congratulations again. And just as a friendly reminder, there is the National Trial Competition the weekend of February 20th through the 22nd. Would love to have both of you sign up as a bailiff or a witness if you haven't already. Congratulations.
Thank you.
then they didn't want to get us a card.
Are my jurors ready to proceed? You got your hands up, everything? Okay. Counsel, ready to proceed? I just want to thank you again for accommodating our schedule shift and giving us the chance to have a quick bite for lunch. So thank you, and again, I apologize for making you guys wait, but we really appreciate it. If the both of you are ready and everyone else watching is ready to proceed, then we'll start with our 5th round. Ready? Okay. Calling the case of Nat Cole versus the City of Blue Note. I want to start the round by having counsel state their appearances and what portions of the trial they will be performing today. Let's start with plaintiff's counsel.
Your Honor, Matthew Dooley for the plaintiff. I will be doing direct and closing.
Thank you. And who will you be directing? Which
Your Honor,
witness?
I'll be directing Miss Monica Alvarez.
Sorry, I'm just making a note here. Directing Alvarez and closing, correct?
That is correct, Your Honor.
Appearances for the defense.
Good afternoon, Your Honor. My name is Maylise Arvouet, last name spelled Hervouet, and I represent the defendant, the City of Blue Note today. I will be doing the opening statement, and I will be doing the cross of Nat Cole.
Thank you. And your pronunciation of your last name for me, one more time.
Arvouet.
Arvouet.
Yes.
Dooley. Okay. Cross-examining Nat Cole.
Yes.
Thank you. Okay, well with that, we're ready to proceed with opening statements. We do not have an opening statement from plaintiff, so we'll start directly with the opening statement on behalf of the defendant. When you're ready, Ms. Arvouet.
Yes.
And I'll be providing your 1 minute warning.
Thank you. One moment, one choice. This case comes down to a single moment, a choice that led to an unfortunate injury. It was in that moment, that choice, that brings us here today. The facts of this case are simple. The Blue Note Police Department received a tip that a 13-year-old was involved in a student drug ring. That 13-year-old is Nat Cole. Based on this information, the police department decided to conduct a school bus sweep. On October 25th, 2025, Officer Davis and his partner K9 Max boarded the plaintiff's school bus. As Officer Davis got on board, he gave clear safety instructions. Stay seated, keep your hands to yourselves, and do not pet the dog. These were not suggestions. They were safety commands. And after those safety commands, it was in that moment, that choice, where Nat decided to move. The plaintiff claims that the City of Blue Note is liable for Nat's injury. But today, the evidence will show that it was Nat's choice, his choice to move despite clear warnings not to, that led to his injury. The plaintiff has the burden of proof by preponderance of the evidence to prove their case today. But today, you will learn that they cannot prove their case for 2 reasons. First, Officer Davis gave clear safety commands. You will learn that these safety commands are put in place by the department along with the practice of the department. Second, you will learn that Mr. Cole moved and Max reacted according to his police K9 training. But let's get back to my first point, the safety commands. Today, you will hear from our witness, James Johnson. James will tell you that he was sitting on the bus that morning. He was a classmate and student on the bus. He will tell you that he not only saw as Officer Davis got on board, but he heard the clear, direct safety commands. Stay seated, keep your hands to yourselves, and do not pet the dog. And that brings me to my second point, how Mr. Cole moved during that school bus sweep. James will tell you that from his seat, he saw as Mr. Davis and Max were getting close to the plaintiff's seat, he saw Nat make a sudden downward movement, a movement toward his backpack. James will tell you that Nat moved first and Max reacted second. You will also see a Facebook post in regards to that incident. A Facebook post where the plaintiff jokes about the bite and tells his friends, "Don't tell my mom." Members of the jury, the law recognizes that when someone contributes to their injury, it breaks the chain of events. The evidence will show that it was Nat's decision. His decision to move despite clear warnings not to, that caused his injury. At the end of this trial, after you've seen the testimony and heard all the evidence, I will stand before you and I will ask that you return the only verdict that the evidence supports and that justice demands, not liable. Because members of the jury, when clear safety instructions are ignored, it only takes one moment, one choice.
Thank you, Ms. Arvoit. Let's proceed with the plaintiff case in chief with the direct examination of Ms. Alvarez.
Your Honor, the plaintiff would like to call Ms. Monica Alvarez.
And I will be timing during your direct examination and your cross-examination, so look to me for your 1 minute mark and when time is up. Mr. Dooley, when you're ready.
Your Honor. Good afternoon, Ms. Alvarez.
Good afternoon.
Ms. Alvarez, would you please tell us a little bit about your background?
Yeah, so I've been working for the city of Blue Note in the Department of Public Safety, and I was on their Critical Incident Review Board where I reviewed and oversaw policies, trainings, use of force incidents involving law enforcement officers and canine deployments.
Ms. Alvarez, let's get right into it. Why did you recommend or not recommend Max to be on the school bus that day of the incident?
Well, after reviewing, part of my job is to review all canine and use of force incidents, right? And after reviewing specifically Max's history, I found that he was very temperamental around children, especially school-age children.
Ms. Alvarez, can you clarify temperamental? Were there prior incidents?
That's correct, yes.
Okay, Ms. Alvarez, could you please tell us about these prior incidents?
Yeah, so there were actually, there were 3 incidents in total, spanning from 2022 till the current instance. But there were 3 incidents, 2 involving kids. One was March 2022, June 2023, and December 2024, and then the incident case.
Ms. Alvarez, please tell us about the first incident.
Yeah, so in March 2022, K9 Max, along with his handler, Officer Davis, were doing a school demonstration where K9 Max bit another student.
Ms. Alvarez, please tell us about the second incident.
So that was during a traffic stop. There was contact with a teenager, and that was also with K9 Max.
Ms. Alvarez, please tell us about the third incident.
So that was during a Christmas parade. That one did not involve a child, but that was another instance of where K9 Max was very aggressive. He reacted to another K9 unit and lunged towards that unit.
And Ms. Alvarez, in all 3 of these prior incidents, can you describe in the evidence anywhere why Max lunged out in any of these 3 cases?
Well, Max was it was handler error. The leash was too loose by the handler, and also Max was just temperamental towards kids. In that he was aggressive towards children specifically.
Ms. Alvarez, when was Max certified by post?
It would have to be around 2021, I believe, but I could be mistaken.
If we need to enter, permission to enter Exhibit 7.
Sure. Is it pre-admitted?
It's all evidence, Your Honor, both the rules of court are pre-admitted. It clearly states that permission to approach.
Can you show opposing counsel what the document is first, and then you do have permission to approach?
It says that Max was certified in 2023. Entering evidence from this. let's see. That might be right.
And you can take the document back. I just wanted you to show it to, okay.
All right. All right. Ms. Alvarez, after the incident, can you describe what your role was after Max bit the plaintiff?
Well, like I said, I'm on the incident review board, so I reviewed the entire incident and offered my recommendations.
And Ms. Alvarez, Your Honor, I'd like to publish Exhibit 3 Alpha, permission to approach.
You may. Yes.
There we go, and permission to publish.
You may.
Can you read, before I publish, Ms. Alvarez, can you read right after the red tab line what your initial intent of finding in this incident was?
Right, so the board was considering whether the totality of the circumstances reflected deficiencies in supervision, policy, documentation, and operational planning.
Thank you, Ms. Alvarez. Permission to publish.
You may.
And Ms. Alvarez, permission to enter Exhibit 3, Your Honor.
You may.
All right. If you would read the red tab line, what was your final conclusion?
The conclusion was that the board concluded that these issues did not materially alter the reasonableness of Max's response in this specific instance.
Permission to publish.
You may.
Ms. Alvarez, what does that even mean?
That just means that pursuant to the then existing, or rather non-existing policy, Max is compliant, but it is my opinion that due to the fact that there was no policy, there should have been a policy. And had there been a policy specifically regarding canines and children, Max should not have been on that bus.
The defense rests. Thank you, Your Honor.
Thank you. My understanding is that we,
Or the plaintiff rests.
yes, that we do not have a cross-examination of this witness, right?
That is correct, Your Honor.
Okay. However, we do have a cross-examination of the plaintiff witness, Nat Cole.
Yes, Your Honor.
Okay. You are now Nat Cole. Please proceed with your cross-examination when you're ready.
Good morning, Nat.
Good afternoon.
Good afternoon. Let's talk a bit more about what happened on October 25th, 2025.
Okay,
You were on your school bus that morning,
I was.
and you saw a uniformed police officer get on board.
I did.
You later found out that officer was Officer Davis.
That's right.
And Officer Davis was with a dog, correct?
Yes.
That dog was wearing a harness.
Yes.
The harness clearly stated police canine.
I saw that, yeah.
And as Officer Davis and Max started their sweep, you were in your seat at that moment, right?
I was, yes.
Okay, so let's talk a bit more about the sweep in itself. Before they began the sweep, Officer Davis gave clear instructions, didn't he?
Yeah, I heard him say to keep our hands on our laps and not to.
Objection relevance? Your Honor, just because the instructions were clear to this witness doesn't mean that they were clear to the plaintiff.
Response?
Absolutely. Your Honor, this line of questioning is relevant. A big issue in this case is causation, and the fact that the officer gave clear commands to not move and to not pet the dog, and the fact that Nat decided to move makes it more probable that the city of Blue Note is not liable for this situation. Therefore, it is relevant and admissible.
Mr. Dooley, I'll give you the final word.
Again, Your Honor, just because it was relevant to this witness, it does not make it more probable or less probable that the plaintiff clearly understood the instructions of the officer.
Okay. I believe that's an issue of weight, not admissibility, so I'll rule the objection.
Thank you, Your Honor.
Please proceed.
Thank you. Now, I just want to get back to my last question. Officer Davis said to not touch the dog, correct?
That's right, not to pet the dog.
Okay, so let's move forward to when he started doing his sweep. You had a backpack with you that morning?
Yeah, it was by my feet.
It was by your feet. And when Officer Davis and Max approached your seat, you decided to turn, didn't you?
I don't remember if I made a turn or not. It all happened so quickly, but I did my best to stand still, yes.
But Nat, didn't you move at that moment to check on your backpack?
Like I said, I don't remember. I might have made a motion, but I did my best to follow the commands.
You might have made a motion, and after that, that's when the dog bit you?
Yeah, he bit me really hard on the left arm, and I had to get 6 stitches, and the blood was going through this. I was wearing like a a quarter zip sort of what I'm wearing right now, and the blood was going through the sleeve of that.
I understand that. I'm sorry about that. We're almost done here. Let's just move forward to what occurred after the incident. Are you familiar with Facebook?
I am.
Your Honor, permission to approach the witness with what has been pre-marked and pre-admitted as Exhibit 8.
You may.
Showing it to opposing counsel. Approaching the witness. Permission to publish to the jury.
You may.
Nat, this is your Facebook post, right?
Yes.
And in that Facebook post, you told your friends online about the bite?
Yeah, I said I can't believe it got bit.
Someone commented on that post, right?
Yeah, James did.
And you decided to reply to James?
I did.
So let's get back to the reply of James really quickly. James said, well, what did you expect? You moved.
Yeah, he did say that.
And you replied to that after?
I did.
And when you replied, you could have told James that he was lying.
I could have.
You could have told James that you didn't move.
I could have.
You could have told James that he had the story all wrong.
I could have said that.
But not, instead you decide to say, LOL.
Yeah, I was, trying to be tough.
LOL as in laugh out loud.
Yes, that's true.
And you followed that up with, don't tell my mom.
Yeah, like I said, I'm just trying to act tough.
No further questions, Your Honor. Permission to retrieve my exhibits?
Yes, you may. Thank you, Ms. Arwett. Defense, you rest your case in chief?
Yes.
Let's proceed to closing arguments. We have a closing argument on behalf of the plaintiff, but none from the defense, correct?
Correct, Your Honor.
Mr. Dooley, it's your courtroom.
Thank you, Your Honor. Ladies and gentlemen of the jury, you heard from the defense. You've heard the evidence, or you've heard the testimony, you've seen the evidence. And the defense wants you to focus on one moment, one choice. I believe this is a red herring. This is not a one moment, one choice type of event. The defense is trying to get you to imagine that the plaintiff is on some sort of scale here with the city. On one side, you have Nat Cole, a child, a middle school kid, 13 years old, on a school bus after school. On the other side, you have a city, and that's actions, that one choice, one moment, that day, somehow outweigh the city's actions. This is a red herring, and it's not even a very good red herring. But I'll explore it because it's not a very good red herring. In fact, this red herring is kind of a stinky fish. Kid, middle school, on a bus. On this side of the scale, an entire city. You have Officer Davis, Inspector Alvarez. You have a police chief, their supervisors. You have an entire training function. You have the California post-certification system. You have a city attorney. You have a lot of people that are paid and who took oaths to be responsible for the operation of the city. And on this side, you still have a kid. This isn't one moment, one choice. This is about that dog shouldn't have been on that bus that day. And that began long before this red herring of one moment, one choice. Months, years prior, before Max was even certified, he started biting people. You've seen in the evidence that the city failed to report this. Now, you've heard testimony, and you might have seen a little bit in the evidence where Officer Alvarez flip-flopped a little bit. Maybe out of self-preservation, we don't know. She was eventually fired. But Officer Alvarez, even though she has her grudge with the city, was part of the city function that day, before and after, when she still was flip-flopping. This isn't one moment, one choice. Max should not have been on that bus. What we're seeing here from the defense is victim blaming. We in America, in American justice, we don't go up to the domestic violence victim and say, wow, that's a pretty good shiner. What did you say to earn that? We don't go up to a rape victim and say, well, we're sorry about your situation, but miss, why did you wear that dress out to the club that night? And we don't say, well, kid, when that dog ripped into your muscle and tendons and ligaments and caused that damage, did you move? California post-certification doesn't allow a dog to attack, not once, not twice, not 3 times, just because somebody moved. And despite the testimony, there is nothing in the evidence that came to a conclusion that that dog attacked anybody just because they moved prior to this. We don't know why this dog spontaneously attacks. The dog should not have been on the bus. Earlier in the trial, you saw documents that indicated that the city made decisions because of budgetary reasons. It considered Max not being on that bus. Max shouldn't have been on that bus for budgetary reasons. The dog could have been outside the school bus that day as the kids shuffled through. They could have used another dog. They had options that were not budgetary. The city just failed to act. It has a culture deeply ingrained, not just with this incident, but you've seen overall with Officer Alvarez's firing. Dog should not have been on that bus. It was not this one moment, one choice that this defense wants you to focus on. This incident started in 2022, and this one moment was just the result of the city's failure to train and supervise not just Officer Davis and Max, but Inspector Alvarez, letting her get away with her constant flip-flopping. Even Officer Alvarez, that day, after her recommendation, 5 days prior to the event, she could have taken more action, non-budgetary. She wrote a strongly worded letter. Is that where she ends? She could have shown up that day. She could have made a stand if she truly thought that there was some sort of threat to the children that day. She could have done more, and she was responsible through her oath to do more. Max should not have been on the bus that day. I'm going to leave you with one final question. If you truly think that the city's not liable, tomorrow, if somebody you knew had an 8-year-old kid at a parade tomorrow, the city said, oh, policy's updated, everything's good now. Would you put him on? You must find for the plaintiff. Thank you.
Thank you, and that concludes our trial. Congratulations. Congratulations on making it to the final rounds. I know the hard work and the time commitment and the preparation that it took to get to this point. So I hope that you both are very proud of yourselves. I know we're all very proud of you in the performance that you just gave today. And thank you for everyone in the back who's here supporting. I want to remind both of you that there is going to be a reception here in the courtroom at 5:15 to 6 p.m. tonight, where we're going to announce the top 3 advocates as well as individual awards. So I hope to see both of you there. And again, congratulations, very nicely done. And if you haven't already signed up for the national trial competition, I know that you have,
Yes.
Sarvwet. Mr. Dooley, if you haven't signed up for the national trial competition yet as a bailiff or witness,
Thank you.
friendly reminder to do
I would
so.
love to do it.
We would
I'll
love
have
to
to
have you.
ask
if
the
you're free.
family.
Yes. You want to take a photo?
Yes, yes, yes.
So as the next group comes in,
Yeah,
we'll
back.
take a photograph of you
The
all.
long ones.
next minute or two. While we're waiting, while we're prepping our tables, if you could tell me your appearances just off the record, and then we'll do it formally on the record as well. So for plaintiff?
Sydney Navarro. Sydney
Spell Sydney. Yeah, thank you.
SYDNEE, and then Navarro, NAVARRO.
You have signed up for NTC.
I did.
Yes, okay.
Yes.
I was going to say your name is very familiar to me.
Time to be a bailiff, so.
Yes, fantastic. And then defense.
Isabella Acosta.
That's right. And you're going to sign up, aren't you?
I'm hoping to.
Yes.
Okay.
Okay.
I know eventually they want to come on, so then, like with you, we want everything we want umbrellas, so it's easier, programming's easier.
Jurors, are we ready? Or not?
Yes.
Okay, round 6. Counsel, are we ready?
Yes, Your Honor.
And our supporters in the back, are we ready? Yes, okay. All right, calling the case of Nat Cole versus the City of Blue Note. Let's start with appearances from counsel, and please state what portions of the trial you will be performing today. Let's start with the plaintiff.
Good afternoon, Your Honor. My name is Sydney Navarro. Navarro spelled Navarro, and I will be representing the plaintiff, Nat Cole, this morning, or this afternoon, and I will be performing a direct and closing argument.
Excuse me, what witness will you be directing?
I will be directing Monica Alvarez.
Excellent. For the defense.
Good afternoon, Your Honor. My name is Isabella Acosta, spelled Acosta. I have the honor to represent on behalf of the City of Blue Note, and I will be directing Officer Davis and then providing the closing.
So 2 directs and 2 closings. All right, this is our first today. I like it. All right, we'll battle it out in closings. All right, are both of you ready to proceed?
Yes, sir.
Okay, since there will be no opening statements this round, we're going to jump right into the plaintiff case in chief. And Ms. Navarro, your witness.
Your Honor, I would like to call Monica Alvarez to the stand, please.
Ms. Alvarez, I will be, just as a side note, I will be providing your time during your direct examinations. And then Mr. Allen, who is playing both your witness, and will be providing your time during your closing arguments, okay? Ms. Navarro, when you're ready.
Good afternoon, Ms. Alvarez. I would like to first start with learning a little bit more about you. So can you please share who you are?
Good afternoon. My name is Monica Alvarez. I was the senior investigator for the City of Blue Note in its Department of Public Safety, specifically in its Critical Incident Review Board.
And what were your duties as a senior investigator?
So I worked very closely with our police department. I reviewed trainings, policies, canine deployments, as well as use of force incidents.
I would like to learn a little bit more about one of those canine deployments, specifically the one on October 25th. Did you investigate an incident that happened on October 25th, 2025?
Yes, that was involving the canine officer Max and his handler, Officer Davis, and Nat Cole.
And could you please describe the situation that happened on that day?
Right, so there was an operation that was conducted by the City of Blue Note's police department regarding a drug sales ring at the middle school. In conjunction with the middle school, the police department worked to investigate the possession of drugs and drug paraphernalia, and they went on board a school bus to conduct a search of those things.
And what happened during that search?
That's when there was an incident involving the canine Max and Nat Cole, where Max bit Nat.
I'd like to learn a little bit more about Max now. Would you recognize a canine report from your department?
I would.
Referring court and counsel to what has been pre-admitted as Exhibit 1, showing opposing counsel. Permission to approach the witness?
You may.
Ms. Alvarez, what did I just hand you?
This is a canine report. These are pretty standard in the office.
Is that a true and correct copy of one of those reports?
Yes, it is.
Your Honor, permission to publish to the jury?
You may.
Ms. Alvarez, could you please describe the contents of that report?
So this is a report of each incident in which Canine Max was involved in, starting in March 2022, June 2022, and then in December 2024.
Could you please describe each of those incidences?
So starting with the March 2022 incident, this
Objection relevance.
Would you like to elaborate?
As Your Honor is aware, under Federal Rule 401, the evidence must show more or less likely a fact, and the incident that he will be describing, Ms. Alvarez will be describing, actually goes over previous training incidences when Max was already certified and trained in the 2025 incident.
And what are the specific dates of these incidents?
The first one that he was describing was March 2022, and the second one is June 2023. In Exhibit 12, it explains that both of these bites were during training.
Okay, thank you. Response.
Your Honor, this is relevant because we are not establishing that they continuously had these trainings. We're rather offering it to show that in its entirety, the department was aware of these incidences prior to deploying Max on the October 25th operation. And that goes directly to one of the elements of the Monell claim, in which the department was deliberately indifferent to the risk that was posed by Max based on the knowledge about those training incidences.
Understood. Ms. Acosta, I'll give you the final word.
This has no tendency to prove his final behavior on the 2025 incidents. As I mentioned before, this was before he completed his entire training. Therefore, he was not at the same level he was during the 2025 incident.
Understood. Ms. Acosta, your objection is overruled.
Ms. Alvarez, would you like me to repeat my question?
Yes, please.
Could you please continue describing the last incident on that report?
So that'll be the December 2024 incident. That was a holiday parade where K9 Max was just conducting regular patrol activities, and the Max lunged after another K9 unit.
And to what extent was the command staff aware of those incidences?
I'm very aware. They've been consistently put on notice of Max's temperament, to put it that way. In fact, I made some of those observations myself and put them on notice.
And how did the department respond given that awareness?
They didn't respond. There was no implementation of a new policy. In fact, I feel like they blew me off.
And I'd like to go a little bit more and expand on that internal knowledge. Would you recognize one of those recommendation emails that you sent to the department?
Yes.
Referring current counsel to what has been pre-admitted as Exhibit 5, showing opposing counsel. Permission to approach the witness?
You may.
Thank you.
Your Honor, Your Honor, Ms. Alvarez, what did I just hand you?
This is an email that I sent to Lieutenant Whitlock, and I CC'd Officer Davis, Max's handler.
And is that a true and correct copy of your email?
Yes, it is.
Your Honor, permission to publish to the jury.
You may.
Ms. Alvarez, could you please describe the contents of that email?
Yeah, I mean, I just put on notice Lieutenant Whitlock as well as Max's handler that I am not recommending Max for deployment, especially to environments involving children, due to his sensitivity to sudden movement and temperament assessments.
1 minute.
And when did you express this concern?
I expressed this concern October 20th, 5 days before the incident in question.
And how did the department respond to that concern?
They didn't do anything to this concern at all.
And how did the department respond, or how did the department did they have any guidelines or anything on the books for these types of operations?
No, so everything that the department had was verbal communications and informal policy, but nothing written down regarding K9s in environments with school children.
Did you find these sufficient?
No,
And did you ever recommend moving to formal policy?
I have, and that's why I believe I was fired.
And how did the department respond to that?
They fired me.
No further questions, Your Honor. Permission to collect the exhibits from the witness.
You may. Thank you, Ms. Navarro. Any further witnesses from the plaintiff?
No, Your Honor. No, Your Honor.
And does the plaintiff rest their case in chief?
Yes, he did.
All right. Defense, it's your case in chief. Call your first witness, please.
Your Honor, the defense calls Officer Davis.
Officer Davis, Ms. Acosta, when you're ready.
Good afternoon, officer. I want to start by giving the jury a sense of who you are and what you do for a living. Could you introduce yourself to the court?
Yes, good afternoon. My name is Officer Davis. I've been in law enforcement for 10 years, and I have been a K-9 officer since 2021.
Were there any specific trainings to become a K-9 officer?
Yes, we had to bond with our dog. and we personally train our dogs as part of the bonding process, and that includes a post-certification process. So post stands for Peace Officers Standards and Training.
Were you assigned a specific canine unit?
Yeah, my dog Max.
Would you recognize a photo if I showed it to you?
I would.
Referring court and counsel to pre-admitted evidence exhibit 9, showing opposing counsel. May I approach the witness?
You may.
Thank you, Your Honor. Officer, how do you recognize this photo?
This is a photo of me and Max.
Would you say this is a fair and accurate copy of yourself and your canine unit?
Yeah, absolutely.
Permission to publish pre-admitted evidence into the jury?
May.
Officer, after receiving the assignment of your canine unit, Max, I want to go over the training that was required by the police department. Was there any specific training that Max had to complete?
Yeah, he had to go through behavioral training, and due to his nature as primarily as a drug sniffing dog, just drug recognition.
What type of training did he go through?
Well, like I said, just behavioral training, how to deal with larger environments, larger crowds, and especially with drugs as well, drug recognition.
Did any of the trainings include school bus environments?
Yes, that's part of the large crowd trainings.
Do you remember how many hours or assignments Max was a part of?
It's got to be at least 16 hours, multiple assignments.
Was this a yearly assignment?
There would be quarterly reviews, and he aced all those reviews.
Directing your attention now to the allegations against the city. There was an operation on October 25th?
Yes, there was.
How did the police department become involved?
We were contacted by Blue Note Middle School that they were suspecting their students of using and selling drugs, and so they asked us to do a drug operation to sniff out any drugs on a school bus.
Was there any specific student called out in that tip?
There was a specific student by the name of Nat Cole, but this is more of a general operation as well.
Okay. That being said, I want to break down for the jury step by step that operation. What did you first do as you entered the bus?
Well, so I entered the bus and I made sure to announce to the kids, hey guys, I know it's a dog, fluffy animal, but please don't pet him, he has a job to do. And I asked them to keep their hands on their laps, keep their backpacks on the ground, and not to make any sudden movements, as that might scare Max a little bit.
Why would you give those instructions beyond just possibly scaring the canine?
Well, he has a job to do. We just want to make it a smooth operation.
After the instructions were given, what happened as you passed just the front part of the bus?
Just the front part of the bus, there was nothing of note, but then Max started to perk up and he started to bark, which is a sign that he has detected presence of drugs or drug paraphernalia, and that's what directed me towards Nat Cole's seat.
I remember you mentioning Nat Cole was what the tip was about. Where was he located on the bus?
Somewhere around the middle of the bus.
So the canine passed all of the other students without incident?
Yes, absolutely.
Upon reaching Nat Cole, you mentioned he tensed and barked. What happened next?
Nat made a sudden movement towards the backpack. I couldn't tell if he was trying to conceal something or just reach for something. But then that's what caused Max to react and unfortunately bite Nat.
For the tensing up and the barking, what do you, in your professional opinion, believed provoked Max to bark?
The dogs are drug-sniffing dogs. They're trained to react to the presence of drugs or drug paraphernalia. And so Max was reacting to the presence of that, and that's why he indicated to me to look at Nat's backpack.
After all of the operation and evidence came out, was there any drugs found?
No, there were not.
Were there any drugs in the presence on the school bus?
No.
Did you happen to, as you were walking through, when you noticed Max tense up and bark, did you find any trace amounts after evidence came out?
I believe afterwards it came to my attention that Nat's mother uses medical marijuana and that there was possibly presence on Nat's person of residue from that medical marijuana, and that's what Max was likely reacting to.
Time. No further questions.
Thank you, Ms. Acosta.
Permission to collect the exhibits?
You may.
Thank you.
Ms. Acosta, any further witnesses from the defense?
The defense first.
Thank you. Sorry. Let's proceed to our closing arguments. Ms. Navarro, when you're ready.
Failure to act, failure to change, failure to protect. The City of Blue Note's Department of Public Safety acted unreasonably in letting that aggressive and violent Mad Max on our streets and near our children. Today, we bear the burden of proof by the preponderance of the evidence. Imagine you have a scale in which both sides are of equal weight. If, based on the evidence presented today, this scale tips even slightly in favor of the plaintiff, you must find the defendant liable. We proved that Officer Davis, acting within his legal authority, allowed that canine to use excessive force under general department practices. We showed that the department acted with a deliberate indifference to the risk posed by Max, refusing to implement proper policy and causing Nat Cole's injuries. We proved each and every one of those elements to you today. There are 3 failures on behalf of the department. The first failure, inaction. Officer Davis, as a sworn police officer and certified canine handler, failed to take proper precaution when guiding that dog through the tiny bus aisle. As you heard today, that dog bit 2 kids in the span of 1 year, but the department completely disregarded this when allowing Max on that October 25th operation. Officer Davis was Max's longtime companion, and he knew that better leash control was required in this situation, especially given his awareness of Max's bite history. And yet, Officer Davis proceeded to loosen his grip and allowed that canine to lunge at Nat Cole. You also heard today that it was generally perceived to be reasonable, Max's behavior given his training. However, canines are not trained to bite or attack upon the slightest scent of drugs or movement. They are trained to bite on command. Max did not follow this training, and a poor boy was hurt because of it. Their inaction is further shown by their continued practice of not reporting bite incidences and continuing to deploy Max despite his bite history. These unwritten rules and practices allowed a child to be injured because they didn't report it when it mattered most. The second failure, making the change. You heard Ms. Alvarez's cries for internal policy change. You heard that she advised against deploying Max on the Blue Note operation, but she was ignored. Ms. Alvarez cared for our community's safety, but it's clear that the department did not. The department refused to have any formal or official policy regarding canines with children in small spaces, and they knew about the unnecessary risks that Max posed to children, but had no policy to ensure that his bite history was accurately documented or evaluated. On multiple occasions, the department had the opportunity to eliminate these risks, but chose not to and brushed off concerns for our community's well-being. The third failure, protecting our community. While Officer Davis did command to release upon contact, he was just like the department he works for. He didn't do so until it was too late. The damage had already been done as Mad Max sunk his teeth into that boy for an excessive 2.7 seconds, more than double his average release time. They failed to look after those they swore to protect and caused a lifetime of trauma and fear for a boy who just wanted to go to school. Long before October 25th, the department ignored numerous concerns and did nothing to take care of our kids. The evidence presented today shows that they turned a blind eye to these potential risks and decided that a child's safety was not worth the extra effort. We proved our burden and showed that while all of this could have been avoided, the department acted with a deliberate indifference in deploying Max despite his bite history, which caused Nat Cole's injuries. So today, members of the jury, I ask you to protect what the city failed to and find the defendant liable. Thank you.
Thank you, Mr. Barlow. Ms. Acosta, closing argument for the defense?
Yes,
when you're ready.
Thank you.
Safety is only guaranteed when instructions are followed. The facts are clear, and so were the simple instructions that Officer Davis gave at the time of the incident. My name is Isabella Acosta, and at the beginning of this trial, we asked you to focus on one question. What made Mr. Cole different from every other student on that bus? The answer is clear. Mr. Cole had trace amounts of marijuana on his person, and he moved. The only reason we are here today is that Mr. Cole did something he was not supposed to do. Mr. Cole did something that no one else was supposed to do, and what no one else did. That is why we are here. Not because of anything the city did, not because of anything the certified canine did, but because of what Mr. Cole did. Because safety is only guaranteed when instructions are followed. Before we talk about the true story, let's talk about who has to prove what today. It is the plaintiff's job, and their job alone, to prove more likely than not every element of a Monell violation has been satisfied. Today, they have failed. Let me walk you through the story, the side that the plaintiff has tried to distract you from. Their claims of unauthorized legal authority, excessive force, and harmful policies. The plaintiff claims that the officer acted beyond legal authority, but Officer Davis acted reasonably given the circumstances. This was not a drill or some practice exercise. This was real life. The plaintiff also claims that excessive force was used beyond a reasonable officer's perspective. But in that moment, Max made contact with Mr. Cole in response to the threat he posed from his sudden movement. When there is a certified canine on active duty, common sense tells us when instructed, do not move. We should not move. But Mr. Cole did exactly that. He moved. So the certified canine responded with reasonable force to a reasonable threat. You have been asked to decide whether there is an official policy that was the moving force behind the injuries. But the evidence shows it was not. The moving force was Mr. Cole's own actions, not the city's. The plaintiff has proved one thing. Mr. Cole was injured. An injury that did not have to occur. It occurred because clear safety instructions were not followed. When those instructions are followed, injuries like this simply do not occur. Because safety is only guaranteed when instructions are followed. Members of the jury, the city is committed to protecting our schools, our children, and our community when a threat arises. This case is not about a city policy or practice. The plaintiff was unable to prove a Monell violation because none exist. As the Safety Review Board, the plaintiff's own witness even said from her own biased testimony, the city, the policies, and Max's behavior was evaluated. But the conclusion was clear. Max was fit for duty and not at fault. What happened that day was from Mr. Cole's own actions, not the city's. Because safety is only guaranteed when instructions are followed. And Nathan Cole didn't follow the most important one. Return a verdict of not liable.
you, Mr. Costa. Thank you, Your Honor. And that concludes our trial. Congratulations to both of you for making it to the final round. This was a particularly excellent round. Everyone has been doing amazing so far. I hope that both of you feel incredibly proud. I know that we feel very proud of you, and those of you who are in the back, friends and family who came to support you, I know we're exceptionally proud of both of you. Congratulations. You both worked incredibly hard. It showed in your performance, so I hope you walk away just really with an interest in trial work in particular. So just a friendly reminder, the reception rather is tonight at 5:15 to 6 o'clock. At that time, we'll be announcing our top 3 winners as well as individual awards. I hope that both of you are there. And again, congratulations. Very nicely done. Thank you. Okay, we'll get started here in just a few minutes. We're just waiting on one more judge to return. Van Groningen Rosado. It's a long last name, but it's actually easy to pronounce.
Oh, good.
Yeah,
Not bad, yeah.
Van Groningen.
Well, the actual pronunciation is
Something
bizarre.
quite different.
Impossible, yeah.
What is the actual pronunciation?
Van Groningen.
I'm not even gonna attempt that. Yeah.
There it is.
Yeah, exactly. Yeah.
Dutch.
Yeah. Okay. Are we ready to proceed? Yes. Okay. Friendly reminder. This is round 7. Council, are you ready to proceed? Yes. Yes. Okay. Then let's call the case of Nat Cole versus the City of Blue Note. Let's start with appearances from the parties, starting with plaintiff. And if you could both state for the record what portions of the case you will be performing today, along with your appearance. Plaintiff's counsel.
Ezra Van Groningen for Nat Cole. I will be crossing Officer Officer Davis.
And opening or closing?
Opening.
Opening statement and crossing Officer
Davis.
Okay. Counsel for the defense.
Hannah Rosado, I'll be doing the opening and cross-examining. I'm representing the City of Blue Note, and I will be cross-examining Monica Alvarez.
Wonderful. So 2 openings, 2 crosses, correct? Mm-hmm. All right. With nothing further from the court, let's proceed with opening statements, and we'll start with plaintiff's counsel, Mr. Van Groningen, when you're ready.
Here you are.
And again, Mr. Allen on your back left corner there is going to be providing your time.
A pattern of danger with a trail of warnings and a child that this city failed to protect. Throughout this trial, you will hear how the City of Blue Note intentionally and negligently fielded a canine with a dangerous history. How they papered over the dog's bites by failing to report to the state registry despite regulations, and how they pointedly ignored warnings from their own safety department about the danger of fielding this dog. When a police department cuts corners, we all pay the price. And today, that price is a child. We never look at dogs the same way. It's a bus full of children who had to watch their friend get attacked and couldn't do anything about it. And it's a public employee who was fired just for doing their job. This is not a trial of a simpler handler error, nor is it a trial of a city making a miscalculation. No, this is a trial of systemic negligence that led to the mauling of a 13-year-old boy. This was a pattern of danger with a trail of warnings that led to a child that the city failed to protect. Throughout this trial, you will hear from Safety Advisor Monica Alvarez about how he repeatedly communicated the dangers of fielding K-9 Max and how those communications were met with indifference, hostility, and eventually their termination. You will then hear from the officer about how he brought Max aboard the bus, weaving through the tight aisles and backpacks, and brought the dog right up to 13-year-old Nat. And how the dog, eye level with Nat, barked in his face. When Nat flinched, he latched onto his arm, holding for 2.7 seconds, over double what the training requirements would stipulate. Now, defense counsel is going to try to suggest that it was Nat's sudden, unforeseeable movement that led to the catastrophe today. That it was so sudden that the dog was just doing what it was told and it couldn't have done anything else. But we ask you, what child, eye level with an attack dog barking at their face, wouldn't flinch? What child would not make a sudden move? This was definitionally foreseeable. At the conclusion of this trial, the judge is going to instruct you on the law. And we are confident you will come to the only conclusion that the evidence supports and that justice demands. And you will find for Nat Cole. Thank you.
Thank you, Mr. Van Groningen. Opening for the defense, Mr. Rosado.
Hindsight is human. It's how we respond to difficult situations after they occur. But hindsight is not the legal standard to apply to this case. This case is not about whether the city of Blue Note was perfect. No city is. Instead, this case is about whether a story told after the fact, shaped by hindsight and by emotion, can stand in place of actual proof that the city did something wrong. When a child is injured, our instincts take over. It's human for us to want to find something to blame. We might think, if something had been done differently, that this outcome would not have occurred. This is the basis for the plaintiff's argument this afternoon. They would have you hold my client, the defendant, the city, liable for an accident that in hindsight appears avoidable. But the law does not ask that. So first, I would like to walk us through the events of October 25th, 2025. Officer James Davis and his assigned canine partner Max are on a school-authorized narcotic sweep. Immediately upon entering the bus, Officer Davis notices how narrow the aisle is. There's students on either side and backpacks line the floor. He tells the students to stay in their seats and to keep their hands to themselves. He also recognizes that this will need careful movement. As he approaches the middle of the bus, he notices that Max's behavior changes. He becomes tense. He emits a bark. This indicates that he has detected something. And then he sees a student, which is Nat Cole, make a sudden movement to his backpack. He doesn't know at this time whether that movement is to conceal something or whether it poses a threat. Max then responds to that movement by engaging with a brief contact. Immediately, Officer Davis issues a verbal command, and immediately, Max releases. Officer Davis then radios for medical assistance, and he stays with Nat Cole until he can be seen by the school nurse. Members of the jury, what happened that day reflects what Max has been trained to do, extensively so, for years. He was trained to detect drugs. He was trained to respond to specific cues, and, when appropriate, to engage in contact and to immediately release upon command. Today you will hear testimony from city employees. The previous senior investigator for the Department of Public Safety, Monica Alvarez, and Officer James Davis himself, who will speak of Max's training and the certifications and evaluations that city policy required that he complete and pass before being approved for deployment that day. While hearing of these policies, you may think to yourselves that they sound perfectly thorough and reasonable, because they are, and they reflect regionally accepted norms. You may also think to yourself that, in theory, there could be improvement. It's important that you note that this is not the basis for the law. The law does not ask that we hold a defendant liable for a policy that is not perfect. The law only allows you to find liability where a policy or practice reflects a deliberate indifference to an obvious risk. Deliberate indifference is a high standard, and it's high for a reason. It is not the intention of the law to punish defendants like the city for accidents that occur despite good faith efforts to ensure public safety. Today you will hear of Max's and Officer Davis's long history of compliance with city standards. You will also hear that when issues arose, the city addressed it, corrected it, and reinforced its commitment to safety. That is not deliberate indifference. That is responsible governance. Plaintiff's counsel has a high burden this afternoon, and I am confident that after reviewing the evidence carefully and without the benefit of hindsight, you will see that that burden has not been met. And when you do, the law and justice requires that you find in favor of the city of Blue Note. Thank you.
Thank you, Ms. Rosado. Ms. Rosado, remind me, who are you cross-examining?
Monica Alvarez.
We're going to proceed with plaintiff's case in chief. We'll pretend as if there was a direct examination of Ms. Alvarez. So, Ms. Rosado, your cross-examination.
Good afternoon, Ms. Alvarez.
Good afternoon.
I'd like to begin by talking with you about your role for the Department of Public Safety. Could you explain what that was?
Yes, so part of my responsibilities was working on the Critical Incident Review Board, where I worked in tandem with the police department to review use of force incidents, canine deployments, as well as reviewing policies and trainings.
Great. And in your affidavit, you mentioned a $350,000 city investment into the canine training program. Was this the program that trained Max?
Yes, it is.
And what was included with that program?
A number of things such as quarterly reviews, behavior training and assessments, just general trainings.
And they train to detect drugs?
That's true, that Max is a drug sniffing dog primarily.
Mm-hmm. And they do quarterly evaluations?
That's correct.
And post certifications?
That's true.
And also environmental evaluations as well?
Correct.
What kind of environments?
Usually with large crowds.
Okay. I'd like to speak about Max's compliance record. Do you recognize this?
Yes, this is K9 Max's, excuse me, this is the policies and trainings regarding canines and specifically regarding, yeah, this is K9 Max's training compliance records from the years 2023 through 2025.
So he was post-certified in 2023?
That's correct.
And recertified in 2024?
Correct, in 2023 and 2024.
And he also completed 16 hours of environmental evaluations, is that correct?
Correct.
And this was in schools?
Yes.
Buses?
Sure.
And crowds?
That's right.
And with children?
Yes.
And how was his behavior?
Well, I mean, if you look at this document, he's deemed highly controllable. However, I would disagree with that.
Okay, I would like to move to the events of October 25th, 2025. The purpose of Max's deployment, it was to detect drugs?
That's true.
And that's what he's trained to do?
Correct.
And there was drug residue found on Nat Cole's clothing, is that correct?
That is right.
And wouldn't it be reasonable for him to have detected that on his clothing?
Yeah, he's trained for that.
Okay. And do you recognize this email?
Yes, this is an email from the Internal Review Board, of which I'm a part of, to the Chief of Police, Randall Myers.
And after an incident like what occurred on October 25th, what sorts of evidence does the Critical Incident Review Board review to make a determination?
We review the incident report, the handler statement. That's just another way of saying the canine officer, in this case Officer Davis. We interviewed a number of students, looked at medical records and any videos that were on the scene.
Great. And after reviewing all of that evidence, what was the finding of the review board?
The Internal Review Board found that Max's response to this specific situation was within policy. However, I would note that this policy was unwritten.
No further questions. Thank you.
Plaintiff, you rest your case in chief. Defense is now your case in chief, and we will proceed forward as if you had just conducted the direct examination of Officer Davis, in which case Mr. Van Groningen is your cross-examination of the witness.
Thank you, Your Honor.
When you're ready.
Good evening, Officer Davis.
Good afternoon.
I'd like to start with Max's previous bite incident history. Referring court and counsel to what has been pre-admitted as Exhibit 1. The record reflect I am showing opposing counsel. Permission to approach the witness for the same.
You may.
At the top there, it notes that in 2022, Max bit a child during a school safety demonstration, isn't that right?
That's right.
And your office failed to report this bite, didn't they?
They did.
Okay, and then next, it also says that Max bit another minor during a routine traffic stop, right?
It says that there was brief contact with the teen passenger.
Oh, brief enough that, or serious enough that your department had to settle in a lawsuit.
Yes, they had to settle. I don't know the specifics of the lawsuit.
And again, they were deliberately indifferent to the state regulations when they failed to report this. Isn't that true?
I would not agree with that.
Oh, but they did fail to report it, right?
They did fail to report it.
And then later, in 2025, Max lunges at another officer's canine during a parade, right?
2024.
Okay. And it was a serious enough offense that the other department's lieutenant sent a memo to your office suggesting that Max not be deployed for public engagements. Isn't that right?
That is true.
Okay. Now turning to Max's training and compliance records. Referring court and counsel to Exhibit 12, which is pre-admitted.
Okay.
The record reflect I'm showing opposing counsel. All right. Permission to approach the witness the same.
You may.
And as you testified earlier, Max has passed all of his quarterly and training requirements, right?
That's right.
And you'll note on there it says that Max is highly controllable.
Correct.
But you have had trouble controlling him in the past, haven't you?
And I would blame myself for that.
Okay, you blame yourself when he attacked the minor during the school safety demonstration, right?
That was my loose grip.
What about in the routine traffic stop when it was not deemed officer error?
I'm sorry, what's the question?
What about in the routine traffic stop where it was not deemed handler error, he still lunged at the child, didn't he?
He did.
Right. And then during the parade, again, nothing that says it was handler error, we still lunged at another canine, right?
He did.
All right, and you still contest this represents highly controllable?
I would say he's highly controllable.
Even after the October 2025 incident when Max barked at Nat and you issued the command to heel and you ignored that and lunged at Nat, this is still consistent with highly controllable?
I would say so, yes.
Okay.
I think the totality of the circumstances, he was controllable.
Okay. It also says on there that he's steady around kids, doesn't it?
Yes.
But this October incident marks 3 times where Max has attacked and bit a minor, isn't that true?
Yes.
In fact, the only times that Max has ever had any bite incidences have been with minors, isn't that true?
Sure, yes.
And do you still contest that this reflects being steady around kids?
I think he's still steady around kids if you consider the totality of the circumstances.
The totality, right. Isn't it true that Max goes on about 9 public excursions a year?
Sure, yes, around there, maybe more.
And he's been deployed for about 3 years, and so 3 minor bite incidences out of about 27 total. That's pretty good for you. You like that ratio?
I do.
Okay.
1 out of 9. If you reduce the fraction, absolutely. Again, considering the totality of the circumstances.
Thank you. No.
1 minute.
Referring court and counsel to Exhibit 5, which has been pre-admitted. Let the record reflect I'm showing opposing counsel. Permission to approach the witness the same.
You may.
You recognize this, right?
Yes.
This is the email your own safety department sent you 5 days before the incident, isn't it?
It is.
And in that email, they suggest specifically to not deploy Max because of his tendency towards sudden movements and the environment of tight aisles and juvenile behavior, right?
Sure, they said that.
but your office acted with deliberate indifference when they changed nothing about the plan.
I would disagree with that.
Well, you could have easily put a muzzle on Max, couldn't you have?
Maybe.
You could have easily had the children leave the bus and then swept the bus and children independently.
Sure.
But you did nothing.
We did something. We followed our policy.
Right. Thank you, Your Honor. No further questions.
Thank you, Mr. Van Groningen. With that, the defense rests the case in chief. We have no closing arguments, correct?
That's correct.
And that concludes our trial. Congratulations, both of you. I want to congratulate both of you again on making it to the final rounds of this competition. It takes a lot of hard work and time and effort and blood, sweat, and tears to get to this point, and so we appreciate all of the hard work that you put into this, and it definitely shows in each of your performances today. So again, congratulations. I hope that both of you are very proud of the work and the effort that you put in. A reminder that our reception is tonight from 5:15 to 6 p.m. here in the courtroom, where we will announce our individual awards as well as our top 3 advocate winners. So I hope both of you are there. Congratulations again.
Thank you.
We started in 10 minutes, right?
Yes.
I need to call it 9.
I forgot the whole part.
Work together, right?
Is there
I was like, oh, I know I forgot parts. I didn't
Is
even
there
get
a schedule over by one of you guys?
Oh, we're done.
solving the world's problems over here.
I love that. No, you know what? Then have at it. Yeah. We'll come to you. Exactly. Everything will be resolved. You got it. Friendly reminder: this is round 8 for your scoring sheet. And counsel, are you ready to proceed?
Yes, Your Honor.
All right. Calling the case of Nat Cole versus the City of Blue Note. We'll start with appearances on the record from both parties, as well as what portions of the trial you will be performing today. Let's start with the plaintiff.
Yes, Your Honor. Good afternoon, Your Honor. My name is Katie Wood, counsel on behalf of the plaintiff, Nat Cole. I will be doing the plaintiff opening as well as the cross of James Johnson.
Thank you, Ms. Wood. And for the defense.
Good afternoon, Your Honor. My name is Taya Falcone. I will be counsel for the defendant in this case, the City of Blue Note. I will be doing the opening and crossing Nat Cole.
Thank you. Ms. Falcone, okay. With nothing further from the court, let's proceed with our opening statements, starting with Ms. Wood.
Yes,
when you're
Your
ready.
Honor. Permission to make use of the well.
Of course. And there is a podium here for both of you to use during your openings and during your crosses. Should you need it, it's here for you.
Yes, Your Honor.
When you're ready.
You can't cut corners with a canine. The City of Blue Note and the Blue Note Police Department failed to protect one of its citizens, a 13-year-old named Nat Cole, when they cut corners and neglected to implement appropriate policies and safeguards for their police canines. On October 25th, 2025, the students of Blue Note Middle School, including Nat Cole, were waiting patiently on their school bus, ever so excited to get started with their school days. But before they could go off to class or turn in their homework, at 8:05 a.m., Officer Davis stepped on to the school bus. And this officer wasn't alone. He was holding a leash. And at the other end of that leash was a police canine. Now, this wasn't just any canine. This was Max. Max had a history of biting children. As you'll hear today, members of the jury, in 2022, Max bit a child during a safety demonstration. And again, in 2023, bit a teenager during a traffic stop. And what did the city do to address these concerns? Well, the answer to that question is nothing. Instead, they put Max on a school bus full of children, and it was packed with barely any room to move. Officer Davis and Max marched through the bus aisle so close to the students that it was almost impossible not to make contact. And Nat, well, he was doing his very best to keep his hands to himself. Do as Officer Davis told him, don't touch Max. But unfortunately, this simply was not enough to avoid the inevitable. Officer Davis loosened his grip on Max's leash against protocol. And when they got to Nat Cole's seat, Max lunged at the middle schooler, biting him hard on the arm. Nat couldn't join his peers at school that day because he was busy at the hospital getting 6 stitches. Now, as the plaintiff in today's proceedings, we hold the burden of proving a Monell claim against the City of Blue Note by the preponderance of the evidence. This means, members of the jury, that if you find that our case is more likely than not, then you must find in favor of the plaintiff today. A Monell claim consists of 6 elements which we will prove to you today. 1, that Officer Davis acted with legal authority. 2, that he used excessive force. 3, that the city's customs were the driving force behind the violation. 4, that the city acted with deliberate indifference. 5, that their inaction caused the injury. And finally, that the injury occurred. In support of our case today,
You'll hear from Monica Alvarez, a former senior investigator with the city's Critical Incident Review Board. She will explain how the city lacked any policies regarding canines in enclosed spaces or with minors. You'll hear today that she urged the city to implement such policies, but her pleas fell on deaf ears. The city opted to cut corners. Ms. Alvarez will explain how, in her opinion as an investigator, proper documentation of Max's incidents, as well as implementation of better policies, could have prevented that violent encounter. And finally, you'll hear about Nat Cole, about the pain he suffered despite following all of Officer Davis's instructions that day, and how that pain could have been avoided if it weren't for the city's inaction and lack of policy for canine safety. Because when it comes to safety, you can't cut corners with a canine. So at the end of today's trial, we will ask you to find the city of Blue Note liable. Thank you.
Thank you, Ms. Wood. Opening statement on behalf of the defense, Ms. Falcone, when you're ready.
Thank you, Your Honor. Counsel, may I read this one? Of course. No indifference, no failure, and no Monell. Moments ago, the plaintiff stood before you and told you an emotional story about a minor being hurt. And let me be clear, that part is not in dispute. Someone was hurt, and that was a tragedy. But that's not what actually happened. There were gaps in that story. And it's important you hear what fills in those gaps. So let me tell you what actually happened on the morning of October 25th, 2025. Officer James Davis, a 10-year veteran with the City of Blue Note Police Department, and Max, his certified canine partner, stepped onto a school bus that morning. They were there because the police department had received a tip about a possible drug raid happening at the Blue Note Middle School. They were there to keep the community safe. And as Officer Davis stepped aboard the bus with Max, Max was on a leash, wearing a harness, clearly labeled police canine. Officer Davis also issued a clear command to all of the students to stay seated and to not touch the dog. And as they made their way through the aisles, Max became alert in front of one seat, Nat Cole's seat. But what Officer Davis and Max didn't know, and couldn't have known, was that Nat Cole would disobey and ignore the clear command from Officer Davis and make a slight, sudden movement towards his backpack on the floor. The bus was tight. The aisles were narrow. Students were seated close together. There was very little room to move. And in a confined space, within inches of a trained police canine dog, Nat Cole made a movement towards his backpack. And unfortunately, Max reacted. But Max reacted as a certified, trained canine police dog does. This was not indifference. This was not a failure. And this was not a Monell violation. Good afternoon. My name is Taya Falcone, and I'm here representing the defendant in this case, the City of Blue Note. The plaintiff has brought forth a Monell violation, which requires them to prove that the City of Blue Note, through its policies and its customs, acted with deliberate indifference to create a constitutional violation. The evidence will show they cannot meet this burden. You won't hear that the city's policies or customs encouraged this behavior. You will instead hear that what happened was a sudden downward movement in a confined space that nobody could have anticipated. And that is why the City of Blue Note is also bringing forward the affirmative defense of contributory negligence. You will hear from Officer James Davis, a 10-year veteran with the City of Blue Note Police Department. He will tell you that the city takes public safety seriously and that Max passed all of his trainings, his evaluations, and his certifications. He will also tell you that he followed his training and he acted immediately to regain control of the situation. Additionally, you will hear from James Johnson, who was on the bus that morning, and he will tell you Nat Cole moved, and that the only person who got injured was the one person who didn't obey Officer Davis's clear commands. The one person who moved. You will not hear that the city encouraged reckless conduct, ignored known dangers, or acted in a way that made this injury inevitable. When you apply the law to the facts of this case, do not do so with hindsight, but do so through the perspective of a reasonable officer in that moment. And we are confident you will find that the city of Blue Note is not liable. And at the end of this case, we will ask you to return a verdict in favor of my client. Because there was no indifference, there was no failure, and there was no Monell.
Thank you, Ms. Falcone. Plaintiff, it's your case in chief. We're going to act as if there was a direct examination of the witness, Nat Cole. Ms. Falcone, your cross-examination of the witness. When you're ready.
Thank you. The defense calls forward Nat Cole.
Let's one moment while we wait for the witness to take the stand.
The scoring sheet is having a seizure.
I'll take the blame. Who am I?
You are Nat Cole.
Oh.
When you're ready, Ms. Falcone.
Thank you.
Thank you for your patience.
Good afternoon, Nat Cole. I'd like to talk about what happened on October 25th, 2025. You were riding the bus that morning.
Good afternoon. Yes, I was.
You were seated near the middle.
I was.
Officer Davis boarded the bus
He did.
with Max,
The dog, yeah.
his canine partner.
Yes, that's right.
And the bus, it was narrow.
Yeah,
Students were seated close together,
we were.
and your backpack was on the floor.
It was.
Officer Davis issued a command to the students.
Yeah, he said to keep our hands on our laps.
He said to stay seated
Sure,
and to not touch the dog.
I remember that.
And I want to be clear on what you did in response to that command. You moved.
I don't remember moving. I might have, but I did my best to follow the instructions.
You shifted in your seat.
Maybe a little bit.
Is that your testimony today?
I might have shifted, but like I said, I was doing my best to follow the commands.
You shifted down towards your backpack.
If I did, it was too quick. I didn't mean to do it.
But you shifted down towards your backpack.
Sure.
Is it a yes?
Yes.
Thank you, Your Honor. And then you posted about this incident on Facebook.
I think so, yeah.
Let the record reflect. What I'm holding in my hand has been pre-admitted as Exhibit 8. Referring court and counsel that I am showing opposing counsel permission to approach the witness.
You may.
You posted on Facebook, I can't believe I got bit.
Yeah, I can't believe I got bit.
But I want to be clear on what you responded to after this. Someone replied.
Yeah, Jamie.
James Johnson replied.
Yeah.
And he said, what did you expect? You moved.
He did say that.
And you actually responded to this.
I did.
But I want to be so clear on how you responded. You did not say, that didn't even happen.
No, I didn't say that.
No, you didn't say, that's not even true.
I didn't say that.
You didn't say, the dog attacked me out of nowhere.
I didn't say that.
No, you said, don't tell my mom.
Objection, Your Honor, as to relevance of Nat Cole's statement, LOL, don't tell my mom.
Can you elaborate?
Yes, of course, Your Honor. In order for something to be relevant, it must make a fact of the case more or less probable. Not saying, don't tell my mom, does not make any of the elements of the Monell claim more or less probable, nor does it make defense counsel's affirmative defense more or less probable in this case, Your Honor.
Ms. Falcone, response?
Nat Cole's response to James Johnson on Facebook goes to his state of mind, which is a material fact as to whether Nat Cole knew his actions were reasonable or not, which goes to the defense's claim of a contributory negligent.
May I respond on those grounds?
Yes, final word for you, Ms. Wood.
Not saying don't tell my mom does not affirm that he moved. It doesn't affirm that he thought it was bad. He doesn't say anything but don't tell my mom. We can't infer exactly what this refers to, Your Honor. This is not relevant to today's case.
Ms. Wood, your objection is well taken, but it's overruled.
Going back to my previous question, you said, don't tell my mom.
I said that I was trying to act tough with my classmates.
You laughed.
I wrote LOL. I can assure you I wasn't laughing when I was bit.
No further questions.
Thank you, Ms. Falcone.
Permission to retrieve from the witness?
You may. With no further witnesses from the plaintiff rests their case in chief.
Yes, Your Honor.
Turn over to the defense case in chief, and we will proceed forward as if we had a direct examination of a Mr. Johnson.
Yes, Your Honor, James Johnson.
Thank you. Cross-examination of the witness.
Of course.
When you're ready, Ms. Wood.
Good afternoon, James.
Good afternoon.
I first want to ask you a few questions about why you're here today.
Okay.
You're familiar with Nat Cole?
Yeah, we're classmates. We go to middle school together.
Right, you go to Blue Note Middle School together, right?
We do.
But let's be honest, James, you two don't get along very well, do you?
No, he's mean to me.
Right, he joked around with you, didn't he?
Objection, relevance.
Would you like to elaborate on your objection?
Yes, Your Honor. What does the dynamic between Nat Cole and James Johnson in their personal life have to do with the incident at hand? This is not relevant to the case.
May I respond on those grounds, Your Honor? Of course. This goes directly to James Johnson's credibility. Him saying that they didn't get along goes directly to his bias against Nat Cole. He's here testifying against the plaintiff, Nat Cole.
Sorry, my computer is dying or something. I'm so sorry.
It's all right.
Credibility is always relevant, Your Honor.
I tend to agree. Overruled.
Back to my question, James. He would often joke around with you, wouldn't he?
Yeah, he makes fun of my clothes and the way that I talk.
Right, so because of that, you two didn't hang out very much, did you?
No, we don't.
But you two did take the same bus to school, didn't you?
Yeah.
So you were on the same bus as Nat Cole on October 25th, 2025, weren't you?
Yes, I was on that bus.
And on that day, Officer Davis was on the bus with you, wasn't he?
Yeah.
But Officer Davis also had a police dog with him, didn't he?
Yes, he did.
And this police dog, his name was Max?
I think so.
I want to talk a little bit more about what it was like on the bus that day. There were lots of students on the bus.
Yeah, there were a lot of us.
Right, it was crowded on the bus, wasn't it?
Yeah.
It felt tight on the bus?
Sure, I'm used to it though.
That was a yes, it felt tight?
Yeah.
So tight, in fact, James, that it made small movements feel large.
Yeah, I would agree with that.
And so, because it was so tight, Max was pretty close to the students, wasn't he?
Yeah.
And you even saw Officer Davis loosen his grip on Max's leash, didn't you?
I think so.
Was that a yes?
I think so, yeah.
And after this, Max was even closer to the students, wasn't he?
Sure.
And you feel, James, if it hadn't been so cramped on the bus that day, what happened could have gone differently, right?
Yeah.
Well, let's talk about what did happen. When Officer Davis first entered onto the bus, he gave you guys some instructions.
Yeah, he told us to stand still and to keep our hands on our laps.
Well, James, he actually told you to keep your hands to yourself, right?
Yeah.
And to not touch Max.
Right. Yeah, absolutely. Don't pet him, even though he's a fluffy dog.
Don't pet him. That's what the officer said?
Right.
So you saw Officer Davis and Max go through the bus aisle.
Yeah.
And they eventually reached Nat Cole's seat.
Yes.
And this is when you saw Nat Cole move.
I did see him move, yes.
But you saw him lean down in some way?
Yeah, he moved. He had leant down a little bit, leaned down, excuse me.
But I just want to clarify, James. You didn't see Nat pet the dog, did you?
No.
You didn't see Nat touch the dog in any way?
No.
You didn't see Nat touch Officer Davis?
No.
You didn't see Nat touch any of the other students on the bus?
No, I don't remember that.
And you didn't see Nat touch his backpack, did you?
No, he just leaned down.
So I want to be clear, officer's instructions were to keep his hands to himself, right?
Yeah.
And that is what Nat did that day, right?
Yeah, he kept his hands to himself.
His other instruction was not to pet Max, right?
That's right.
And Nat did not pet Max that day, did he?
No, he didn't.
So he followed all of Officer Davis's instructions.
Sure.
Was that a yes? He followed Officer Davis's instructions?
Yeah, he didn't pet the dog, and he kept his hands to himself.
So it was after Nat followed all of Officer Davis's instructions that you saw Max attack Nat, correct?
Yeah, after after Nat leaned down. Yeah.
But just to be clear, Nat followed all of Officer Davis's instructions that day.
Sure.
And it was only after then that Max bit Nat, correct?
Sure.
Thank you, James. I have no further questions at this time, Your Honor.
Thank you, Ms. Wood. No further witnesses from the defense, is that correct?
Yes, Your Honor.
And no closing arguments on behalf of either party, is that correct?
Yes, Your Honor.
Yes, Your Honor.
That concludes our trial.
Thank you.
First and foremost, incredibly impressive.
Thank you.
Thank you.
Excellent job. Congratulations on making it to the final round. We know, I sound like a broken record at this point, but we know how much time and effort that you guys put in to get it. You both can sit. You've been on your feet for a while. But the time and the effort and the preparation that both of you put into the performances that you gave today, and it certainly showed. I hope that both of you walk away feeling incredibly proud because that was just incredible. A reminder that we have a reception tonight from 5:15 to 6 p.m. right here in the courtroom where we will be announcing our top 3 advocates as well as the individual awards, so please come. And again, thank you to our friends and family in the back who are here supporting the both of you because I know that you guys wouldn't be here without their support. And so again, I just hope that you both feel incredibly proud of what you just did.
Thank you.
Congratulations again. Thank you. This is round 9. We got a nice packed courtroom. Feels like a real trial, so this is good. All right, jurors, are we ready to proceed?
Yes.
Counsel, are we ready to proceed?
Yes.
And the audience are ready to proceed? Yes. Okay. All right, calling the case of Nat Cole versus the City of Blue Note. I want to start with appearances from counsel, and please advise the court what portions of the trial you will be performing as well. Okay, let's start with the plaintiff.
Good afternoon, Your Honor. Kayla Thackeray for the plaintiff, Nat Cole. I will be doing a cross and a closing, and my cross will be of Monica Alvarez, or a direct of Monica Alvarez.
Okay, so just to clarify, a direct of Monica Alvarez and the closing argument on behalf of the plaintiff?
Yes.
Okay. Defense?
Yes, Trevor Adams for the defense. I will be doing a cross-examination of Nat Cole and an opening statement.
ADAMS?
Correct.
THACKERAY?
Yes, Your Honor.
Thank you. All right, let's proceed with opening statement. Plaintiff, you've waived your opening statement, correct?
Yes, Your Honor.
All right, Mr. Adams, opening statement on behalf of the defense?
Yes, Your Honor.
When you're ready. Before you proceed, just for both parties' advisement, Mr. Allen in your back left corner is going to be providing you with your time for your openings and your closing. During your direct and cross of your witnesses, your timer will be me. I just wanted to flag who you will be looking at. Okay. When you're ready, Mr. Adams.
An unfortunate outcome does not mean that you should make an unreasonable decision. This case is about a split-second decision made on a crowded school bus. It's about what a trained police officer and his dog reasonably perceived in that moment. It is not about what we can calmly later analyze from the comfort of this very courtroom. On October 25th, 2025, the Blue Note Police Department conducted a school bus drug sweep after receiving information that a student, Nat Cole, was connected to student drug activity. Officer Davis and his K-9 Max carried out the sweep. As Officer Davis boarded the bus, he gave the students clear instructions. Stay still. Keep your hands to yourself and allow the search to happen. As Officer Davis and Max were working their way down the narrow aisles of the bus, everything was calm. That was until they reached Nat Cole's seat. Max's behavior then changed. He became alert. He changed his posture, and he barked, exactly as he had been trained to do when he detected something concerning. It was at this point that both Officer Davis and another student on the bus, James Johnson, saw Nat Cole make a sudden downward movement towards his backpack. Max then reacted, biting Cole for a few seconds before releasing. Officer Davis stepped in and made sure that Cole received the necessary medical attention. The evidence will show that the City of Blue Note is not liable for two distinct reasons. First, the plaintiffs will fail to show that excessive force was used when judged from the perspective of a reasonable officer actually on the scene, not one with 20/20 hindsight. The law here is clear. An unfortunate outcome is not an unreasonable decision. The law does not require perfection from our police officers or even their dogs. It merely requires reasonableness. Police officers don't get the benefit of hindsight. They don't get to pause, rewind, or see what might happen next. They must make split-second decisions based off of what they see and reasonably perceive as a threat in that moment. The evidence will show that Max's response was reasonable. He responded exactly as he was trained to do when he perceived sudden movements, especially when those movements are made during a drug search, and especially when clear instructions were given to remain still. And second, the evidence will show that Nat Cole was comparatively negligent in causing his own injuries. What this means is had Nat Cole himself not acted unreasonably, none of us would be here today, because none of this would have ever happened to begin with. Despite being given clear instructions to stay still, Nat Cole made a sudden downward movement towards his backpack. Mr. Cole now claims that he never made that movement, but you will hear testimony from both Officer Davis and Nat Cole himself, which tells a very different story. At the end of this trial, I will come before you again and ask for the only verdict that the evidence supports and the only verdict that justice demands. Find the city of Blue Note not liable. Because, ladies and gentlemen, an unfortunate outcome does not mean that you should make an unreasonable decision. Thank you.
Thank you, Mr. Adams. Plaintiff, it's your case in chief. Please call your first witness.
Your Honor, the plaintiffs call Monica Alvarez to the stand.
Ms. Alvarez. Sorry, just give the court 1 second, just making sure my scoring sheet works here. Okay, and this is the direct examination for Monica Alvarez, correct?
Yes, Your Honor.
Ms. Thackeray, when you're ready.
Good afternoon. Please state your name for the record.
Hi, good afternoon. My name is Monica Alvarez.
Thank you. Miss Alvarez, what do you do for work?
Well, I'm currently out of a job, but what I used to do was I was the senior investigator for the City of Blue Note in their Department of Public Safety, specifically in the Critical Incident Review Board.
And were you in this role in October 2025?
Yeah, I served in that position from 2021 until 2025.
Thank you. Could you tell us a little bit about your responsibilities in that position?
Sure. So as part of my role at the City of Blue Note, I reviewed officer use of force incidents, canine deployments, as well as training and policy.
In that role, were you familiar with Officer Davis and K9 Max?
I was.
Since you worked with K9 Max, could you tell us a little bit about his history?
Yeah, so K9 Max had a history of being temperamental with children, especially around school areas. That's to say that K9 Max was aggressive.
Thank you. Were there any prior history of biting?
Yes, so there were 3 aggressive incidents before the current case, 2 of which involved minors.
Were those biting incidents required to be reported anywhere?
Yes, there is a canine incident report which the police department is required to fill out.
So that reporting is a requirement?
There's an internal report system, but they also should be reporting it externally. However, the City of Blue Note did not have a policy of external reporting.
So reporting to the state registry was not a requirement?
It was not something that the City of Blue Note did, unfortunately, although I recommended them to do so.
So were Max's prior bite incidents reported anywhere?
Just internally.
But they were never reported to the state registry?
That's correct.
Thank you. And in your opinion as a safety investigator for the city, why is this reporting important to safety?
Well, it's important so that people understand, and external agencies and risk assessors understand the potential risks that a county or a city police department has, so that they can mitigate that risk and prevent future potential harm.
I'd like to turn your attention now to the incident we're here to discuss, and specifically the policies that were at play there. Did the City of Blue Note have any written policies for using canines around minors?
No, I recommended that the city adopt written and formal policies, but all of them were unwritten and verbal, as well as informal.
Were there any written policies for using canines in confined spaces, such as a school bus?
No, it was all informal and verbal.
What impact, once again, does these lack of policies that were written for those situations have on safety?
Well, it has a huge impact because a lack of written policy means that everyone can effectively interpret. It's like a giant game of telephone. There's no written policy, there's no way to mitigate risk. So it is ripe for future harm.
So there was no written policy. Was there any formal risk assessment required prior to school-based deployments?
There were briefings that were done, but nothing super formal. That was part of my contention with the city and why I believe I got fired.
So without any policy or formal risk assessment, what were officers expected to rely on?
I mean, they relied on their training. I'll give them that, but other than that, it was just their formal training, but nothing to do with like formal K-9 policies regarding school children, which is the problem.
Switching gears, Ms. Alvarez, did you raise any concerns about the lack of policy or the non-existence of the formal risk assessment?
Yes, I reported this to my
minute.
supervisors on multiple occasions, sent them multiple emails, and I didn't get a concrete response, nor was a policy ever adopted.
And when did you send out this communication?
Multiple times, but more pertinent to this was on October 20th, just 5 days before the incident.
And did you recommend any changes in that communication?
I recommended an adoption of a formal policy, but especially when it came to K-9 Max, I warned the department that this dog was extremely aggressive and not to put the dog in the field.
And per your recommendations, were any changes made to how the city of Blue Note acted?
No, nothing, except
Thank you.
firing me.
Thank you. No further questions.
Thank you, Ms. Thackeray. And there is no cross-examination of this witness, is that correct?
That's correct.
There is a cross-examination, however, of Nat Cole.
Yes, Your Honor.
Okay, so we're going to proceed forward as if there was a direct examination of Nat Cole. Mr. Adams, your cross-examination when you're ready.
Yes, Your Honor. Good afternoon, Mr. Cole.
Good afternoon.
You remember the events from October 25th,
I'll never forget it.
and you'd be willing to talk about them with us today.
I guess so.
When Officer Davis boarded the bus, he told the students to stay still
That's right, he told us to stand still.
and not to touch Max.
That's right.
And Max was wearing a harness, right?
I believe so, yeah.
And this harness identified him as a police dog.
Yes,
And you were sitting in the middle of the bus?
I would say that, yes.
And you didn't see, when Max was walking to your seat, him bite any of the other students, did you?
No.
Let's talk about why you may have been the one that got bit.
Okay.
You say you didn't move, right?
I moved slightly, but I didn't try to pet the dog or make any sudden movements.
But isn't it true that you changed your story?
I don't know what you mean.
Well, you said both in your statement that you didn't move and that you don't remember if you moved.
Sure, it was a very traumatic event. It all happened so quickly.
But it just can't be both, right? You either remember or you don't remember.
I mean, I moved slightly, maybe, yeah.
And you're aware that Officer Davis says it was your sudden movement which caused Max to react.
Sure, that's what he said.
Yeah, and which caused Max to bite you, is what he says.
That's what he said.
Yeah, let's talk about something else that you said.
Okay.
You use social media?
I do.
In fact, you made a Facebook post about the incident.
I did.
And do you think you'd recognize the post if I showed it to you?
I would.
Referring court and counsel has been pre-marked as Exhibit 8. Let the record reflect that I'm showing opposing counsel. Permission to approach the witness with the same.
You may.
You recognize this, Mr. Cole?
I did. That's my Facebook post.
Yeah, your Facebook post from November 3rd.
That's right.
Which was 2 days after you gave your statement saying you didn't move and you don't remember if you moved.
I'll take your word for it, sure.
Yeah. And in this post, what you initially said was, I can't believe I got bit.
Yeah, I can't believe I got bit.
And you actually had a classmate on the bus with you that day, James Johnson, right?
Yeah, Jamie.
And he saw the incident, right?
I guess so.
He commented on the post.
He did.
And what James said was, well, what did you expect? You moved.
Yeah, that's what he said.
Yeah, and you even replied to this, didn't you?
I did.
But you didn't say, no, James, you're wrong. I did not move. That's not what you said.
That's not what I said.
Or even, no, James, I don't remember if I moved.
I did not say that, no.
No, Mr. Cole, what you actually said was, LOL, don't tell my mom. That's what you said?
Yeah, I was really embarrassed by this whole thing, and I wanted to act tough in front of my classmates.
No further questions, Your Honor.
Thank you. Any further witnesses from the plaintiff?
No, Your Honor.
Defense, is your case in chief. Any witnesses that you're calling at this time?
No, Your Honor.
Okay. You rest your case in chief?
I do.
Let's move into closing argument. Am I correct in understanding, Ms. Thackeray, you have a closing argument on behalf of the plaintiff. Mr. Adams, you are waiving your closing argument, correct?
That's correct, Your Honor.
Okay. Ms. Thackeray, when you're ready.
Members of the jury, warnings were given, nothing changed, and a child paid the price. It is my job to prove to you that by a preponderance of the evidence, the city of Blue Note is liable for the harm that occurred. All that really means is that if you find it's more likely than not that they caused this harm, you must hold them accountable. At the end of this trial, you'll be given jury instructions. Those jury instructions lay out 6 elements that must be met here. We've proven all of them, but let's go through them now together. First, the legal authority. There is no dispute that this was an official act of the city of Blue Note. Officer Davis was in his uniform, K9 Max was in his harness, the school consented to the sweep. This began and ended as an official act of the city of Blue Note. Next, the reasonableness of the force. Consider the circumstances. This wasn't a wide open area, or the cafeteria, or even a hallway. This was a school bus full of children. There was a narrow aisle, there were backpacks all over the floor, and children seated shoulder to shoulder. That leash was loosened momentarily, but the bite lasted nearly 3 seconds, and the harm required 6 stitches. What might be reasonable in a wide open area is absolutely not reasonable in a school bus full of vulnerable children. Now, the city's policies and practices. You heard from Monica Alvarez, the city's own senior investigator. She told you there was no written policies for using canines around minors. She told you there was no written policies for using canines in confined spaces, such as a school bus. She also told you there was no formal risk assessment prior to school-based deployments. Instead, officers were supposed to rely on informal trainings, or whatever they thought was right, or policies that didn't apply to a very narrow situation involving children in a school bus. Which leads me to my next point, the warnings. Monica Alvarez warned 5 days prior to this incident, just 5 days prior to this incident, that Max was not suitable for a child-dense, condensed environment like a school bus. She recommended changing the plan. She recommended Max not going on this deployment, yet nothing changed. Instead, the city chose to put a reactive canine into a school bus full of children. She also told you that Max had bitten before, and that those prior biting incidents were not reported to the state registry, even though reporting is recommended and required. Lastly, why this happened. Monica Alvarez told you that a formal risk assessment would have considered many factors. It would have considered the presence of minors. It would have considered Max's prior biting history, and it would have considered being in a condensed environment. And likely, had those things been considered, the plan would have been modified or changed. This didn't happen because a seated 13-year-old moved in his seat. This happened because of what the city chose to do, or more accurately, what they chose not to do. Finally, the injury. You heard about the harm and the fear that followed and the 6 stitches that it required. Those things didn't happen in a vacuum. Once again, they happened because of what the city chose not to do. The defense suggested that a seated 13-year-old broke the chain of responsibility. But children move. That is foreseeable. Just ask anyone who has kids. What's supposed to protect them is policy and rules. The exact things that did not exist here. Members of the jury, when you deliberate, think about the rules that did not exist, the warnings that were ignored, and the harm that followed to our most vulnerable people, children. Once again, warnings were given, nothing changed, and a child paid the price. We ask you to find the City of Blue Note liable. Thank you.
Thank you, Ms. Thackeray. And again, no closing argument on behalf of the defense, correct?
That's correct, Your Honor.
All right. That concludes our trial. Congratulations to the both of you. That was an excellent round. I want to first start by thanking the both of you for all the time and the effort that you have put into preparing for this competition, for the very beginning and the preliminary rounds, all the way here to the finals. Congratulations for getting to the final round, and it was a very well-deserved round. I want to thank all of the supporters, friends and families in the back for coming and supporting our two advocates here today, and for supporting the program. I want to remind you that there is a reception tonight from 5:15 to 6 p.m. where we will be announcing the individual awards and the it's been a long day, and the top 3 advocates as well. And I just hope that the both of you walk out of this courtroom feeling an immense sense of pride, and that you showed up and you showed out today. So congratulations. Nice job.
Thank you.
Thank you.
And just as you all are packing up, just a friendly reminder, if you haven't already signed up, we have the national trial competition that McGeorge is hosting. I'm sure you've seen my name and all of the email blasts in your inbox. But we are still looking for bailiffs and witnesses, and we would love to have both of you sign up if you have not done so already. It's the weekend of February 20th through the 22nd. Given your performance today, both of you do an absolutely fantastic job. So sign up.
Thank you.
Thank you.
Thank you.
Sure.
Should I dig down again?
Yeah. Thank you.
I'm on it. I'm behind the chair.
Is she not in our photo?
I mean, she can be.
You can be in our photo.
Ray, have you guys figured out your practice schedule yet?
No, I'm waiting for them to get back to me on when they're here.
Yeah, let me know, and then we'll book all your practice rooms and everything.
Oh, go to this room, I'm like, I don't know which one it is.
It's direct. They're both closing, right?
Yes.
Correct.
Closes.
Correct, close.
Oh, so you get to get.
Yeah, so you get to be up here for it now.
This is my favorite. This is my favorite.
Alright, do we have everyone here for both of you?
Yes.
No, Not yet?
They're almost here.
Okay, alright, we can wait. We can get our score sheets ready though. This is our last round. Last but certainly not least, round 10. No openings. And for purposes of the score sheet, and we'll go on the record once everyone is here. Say your last name for me. Baltiera and Torres.
Veronica Torres.
One more time. Oh, okay, thank you.
Veronica Torres.
Veronica Torres?
Yes.
Okay. For purposes of the score sheet, you'll be advocate 1 and you'll be advocate 2. Just because we have 2 plaintiffs instead of a plaintiff in defense. Ms. Beltier, you will be going first for your direct. No cross. Mr. Veronica Torres, you are second on your direct, no cross. Perfect.
And I know it's gonna be a little trippy because you're both doing the same witness, but just pretend that I literally didn't say anything.
Yeah.
Right.
Yeah. For closing, is there an order?
Yeah, you'll be going first on everything that you do.
Got it.
Yeah.
Thank you. Maybe.
And then I will be sitting in the, what is that, top left for the review?
Yes.
I'll be in that corner. I'll have a 1-minute warning sign when you're at 4 minutes.
And that's for your closing, and then I will be giving you your timing for both of your directs. Okay, so I'll let you know when you have 1 minute and then 1 time's up. Do we have everyone?
Yes.
Yes? Okay, everyone for you as well?
Yes.
Okay, let's start our last and final round, round 10. Calling the case of Nat Cole versus City of Blue Note. I'd like to start with the appearances from the attorneys, and if you could tell us on the record what portions of the trial you'll be performing today. Let's start with plaintiff number 1.
Good afternoon, Your Honor. Mia Baltiera, spelled B-A-L-T-I-E-R-R-A, counsel for the plaintiff. I'll be conducting the direct examination of Monica Alvarez and the closing argument.
And appearances for plaintiff number 2.
Good afternoon, Your Honor. My name is Diego Veronica Torres, and I'm representing the plaintiff, Nat Cole. I'll be performing the direct examination and a closing argument.
And direct examination of Ms. Alvarez as well.
Ms. Alvarez as well.
Thank you. Okay, seeing that we have no opening statements, we will move directly into the plaintiff's case in chief. Ms. Beltier, if you can call your first witness, please.
Your Honor, we'd like to call Monica Alvarez.
Okay. Ms. Alvarez, you're sworn in. Ms. Beltier, the floor is yours when you're ready.
Good morning.
Good afternoon.
Good afternoon. What do you do for a living?
I was the senior investigator for the City of Blue Note's Public Safety Critical Incident Review Board.
What did you do as an investigator?
So I was involved, I worked in tandem with the police department to assess use of force incidents with police officers, canine deployments, as well as ascertaining whether our policies and trainings were up to snuff.
Now, you said you had that job until last year. Do you no longer work with the city?
That's true.
And why is that?
I believe I got fired because of my advocacy for a change in our canine policy.
I want to talk about those policies that were in place while you were working for the city. How would you describe their canine policies?
Almost non-existent. The department had a basic bare bones policy regarding canines generally, but there was no such policy when it came to children, especially schools specifically.
Why was it a problem that the city didn't have a policy for children or schools with canines?
You have to understand that a lot of our police officers conduct school demonstrations with students present. Sometimes we also engage in operations aboard school buses where it's a very tight and narrow confined space. So without a written policy, the risk is just extreme.
Did you inform anyone about your concerns?
Yes, I let the chief of police know, as well as multiple lieutenants, about this issue, but they ignored my warnings.
Are you aware of a planned drug sweep on October 25th, 2025?
Yes, I'm aware of that.
Now, ahead of that, did you have any concerns about what was planned?
Yes, specifically there was this canine by the name of Max, who, in my review and experience of Max's record, was a red flag for me. Max was very temperamental, that's to say very aggressive towards children, and I knew that Max was going to be a part of this operation, so I tried to warn the police to try and get a different dog on that case.
Now, you said you reviewed a record. Would you recognize documentation of Max's history if I showed it to you?
Yes, absolutely.
Directing court and counsel has been pre-admitted as Exhibit 1. I'm now showing this to opposing counsel. Permission to publish to the jury.
Do you want to show the witness first? And has this document been pre-admitted?
It has, Your Honor.
Then you can publish to the jury.
Ms. Alvarez, what is this?
Yeah, so this is the Blue Note Police Department canine report of canine Max, and as you can see here, there are 3 specific incidents prior to the October 25th incident that were very concerning to me.
Could you describe what the first incident was?
So that occurred March 2022. Max was doing a school safety demonstration with his handler, Officer Davis. And in that instance, Max bit a student after the handler failed to maintain proper control of the leash. He held it too loosely.
What was the second incident?
So that occurred June 2022, just a few months later. That was a traffic stop where Max bit a teenage occupant of the car.
And what was the third incident?
So that was a little later, December 2024, and that's when that was an annual holiday parade. Max was conducting preemptive drug sweeps, and Max lunged towards another canine unit that was on the scene that day, and there was a formal complaint lodged by that officer about Max.
When these incidents occurred, were they reported internally?
Internally, yes, but these incidents should also be reported externally to a state review board, and Blue Note did not have that policy, which I strongly encourage them to have.
What effect does not submitting this to the state have?
It contributes heavily to the risk.
1 minute.
The chance of a repeat incident without an external report and an external audit were just through the roof.
I want to talk about your findings regarding the October 25th incident. What were your overall conclusions?
Although Max did not violate the department policy, it's very loose to say that because there was no formal department policy, but Max should not have been on that bus, and in my opinion should not be a canine officer.
I want to be clear, you said that there was no policy. Is this something that you had brought up to the city before?
Yes, multiple times.
Now, if the city had implemented the changes you suggested, do you think the October 25th incident could have been prevented?
It would have been prevented, and we would not be here today.
Thank you, Ms. Alvarez. No further questions, Your Honor.
Thank you, Ms. Beltio.
May I retrieve the exhibit?
You may. Counsel?
The plaintiff calls to the stand Monica Alvarez.
All right, Ms. Alvarez, you will be testifying once more. When you're ready.
Good afternoon. I'd like to start discussing your background first. Can you please introduce yourself to the jury?
Good afternoon, my name is Monica Alvarez.
And Ms. Alvarez, are you currently working?
Unfortunately, no.
Where were you working before?
Before this, I was working as a senior investigator for the city of Blue Note, working in tandem with their police department as a member of their critical incident review team.
For how long did you work there?
I worked there from 2021 until 2025.
Can you please share your responsibilities under that role?
I was in charge of looking over the City of Blue Note Police Department's policies and trainings when it came to law enforcement. I was in charge of investigating use of force by other law enforcement officers and canine deployments.
Now, I'd like to discuss your experience while you were working at the department. Are you aware of Officer Davis and his canine Max?
Yes, I am very well aware of them.
If I were to show you a report showing some incidents from them, would you be able to recognize it?
Yes, absolutely.
Referring court and counsel to what has been pre-admitted as Exhibit 1. Let the record show I'm showing opposing counsel. Your Honor, may I approach the witness?
May.
Ms. Alvarez, what did I just hand you?
This is a Blue Note Police Department canine report regarding canine Max and his handler, Officer Davis.
Your Honor, permission to publish?
You may.
Now, Ms. Alvarez, can you please tell us the incidents that where Officer Davis and canine Max were involved?
Yeah, so there were 3 separate incidents. One occurred March 2022, another June 2022, and one in December 2024.
And how did the city respond to those incidents?
Didn't respond at all.
Objection, Your Honor, propensity evidence.
Can you elaborate?
Yes.
And I'm sorry, before you do, can you remind me of the question?
How did the city respond to those incidents?
Okay, please elaborate.
As Your Honor is aware, under Federal Rule of Evidence 404, evidence of a person's prior acts cannot be used to show that they acted in conformity with those acts on another occasion. Here, this question is asking about evidence of Max's and Officer Davis's prior incidents where Officer Davis mishandled his dog. This could lead the jury to infer that because Officer Davis mishandled his dog in the past, that happened here, and that it's impermissible propensity evidence.
Response?
Your Honor, I am not trying to show propensity. I'm just trying to establish that the city knew of the requirements under the law when responding to incidents.
Understood. I'll give you the final word.
I stand by my argument, Your Honor. Opposing counsel is showing evidence of 3 prior incidents where Officer Davis mishandled his dog, and these were reported. And they are trying to show that because he mishandled his dog in the past, he did so here, which is impermissible.
And I just want to clarify, I understand that you are plaintiff's counsel for purposes of your direct and your closing, but you are making that objection as if you were defense counsel, is that correct?
I am.
Okay. Your argument is well taken. It'll be overruled at this time, though. Please proceed.
So may you share how the city responded?
The city didn't respond at all. In fact, I informed the city of my concerns even after these incidents, and the city did nothing to alleviate my concerns or anything related to these incidents.
So can you share if the city was responsible for sharing those canine bites to a separate agency?
No, so there was an internal report, and this is actually part of the internal report. Other police departments do report the canine incidents to an external state-governed agency. Blue Note did not do so.
But were they required to?
It's standard practice, but it wasn't a requirement internally to do so.
Thank you, Ms. Alvarez. Now, I'd like to discuss the incident that has brought us here to court, the incident of October 25th. Are you aware of that incident?
Absolutely.
Were you involved in the preparation for that operation?
I was, and I, in fact, warned the chief of police not to involve Canine Max in that operation.
What were your concerns with that operation?
Well, my major concern is that given Canine Max's history and how Canine Max was around children, that is to say very temperamental and aggressive, that I was concerned that there would be an incident, and there was one.
And were you involved in the investigation after the incident occurred?
I was.
You drafted a few reports on that?
I did.
If I were to show you a report, would you be able to recognize it?
Yes.
Referring court and counsel to what has been pre-admitted as evidence 3A. Let the record show I'm showing opposing counsel. Your Honor, may I approach the witness?
You may.
Ms. Alvarez, what did I just hand you?
This is an internal review report following the October 25th, 2025 incident.
Your Honor, may I publish?
You may.
Now, Ms. Alvarez, can you share your findings after the incident investigation?
Yeah, I said that
while there were concerns about being in a confined school bus with minors, and one of the major concerns was Officer Davis's grip being really loose on the leash, but I also said that the board was considering the totality of the circumstances before making a formal opinion.
And did all of the findings that you included in that preliminary report made it to the final report?
I believe so, some of them at least.
What were the ones that were omitted?
1 minute.
Just the ones regarding that my concerns about the K-9 Max's presence in the school bus with minors. That was omitted in the main report. I did not want that to happen.
Do you know why they were omitted?
I don't know, but I can take a guess that, they fired me for it, so I don't know.
Because you expressed those concerns?
I expressed these concerns multiple times, yes.
And they were never taken?
Never.
No further questions, Your Honor. May I approach to retrieve the exhibits?
You may. Thank you.
Thank you.
Do you have any further witnesses on behalf of Plaintiff's Counsel?
No, Your Honor.
Any further witnesses on behalf of Plaintiff's Counsel?
No, Your Honor.
Do you rest your case in chief? Yes?
Yes, Your Honor, we do.
Seeing that there is no case in chief presented by the defense, we'll move on to our closing arguments. We'll start with you, Ms. Valtiera, when you're ready. And again, please look to Mr. Allen in the top left corner for your time.
You can't cut corners with a canine. October 25th, 2025, Nat Cole was just another kid on the school bus when Officer Davis and his K-9 Max boarded their bus. He told the kids, keep your hands to yourself. That's what Nat did. He kept his hands on his lap as Officer Davis and his K-9 made their way down the narrow aisle of that bus, crowded with children on either side. They approached where Nat was sitting, and suddenly he was attacked. His arm was locked in the jaws of that dog for several seconds until he finally let go. This was the result. Nat Cole had to receive 6 stitches, and he was left terrified from this attack. This was a direct result of the City of Blue Note's policies. They cut corners with a canine. Now today, we brought a Monell claim. Essentially that the city is responsible for the violation of Nat Cole's rights. Now when you go in that jury room, you're going to get a set of instructions that tell you about our burden and the elements we had to prove. Now our burden today is a preponderance of the evidence. Essentially more likely than not. So when you're weighing the evidence you heard today, if the scale tips in our favor by 50% and a feather, you must find the defendant liable. And you're going to see 6 elements we had to prove to you today. Now, a few of these aren't at issue. The first, that Officer Davis acted with legal authority. And the last, that Nat Cole suffered an injury. Both parties agree on these. And that leaves 4 other elements. That excessive force was used, that the city had a policy that there was the moving force behind the violation, that they knew the risk of harm, and this policy was the moving force behind the injury. We proved each and every element by showing you 3 facts. 1, the city's policies were a problem. 2, the city knew the risk of harm. And 3, Officer Davis's conduct was unreasonable. Let's start with number 1. The city's policies were a problem because simply they were unclear. Their guidelines regarding canines were not detailed. Their real policy was to leave it up to the discretion of each officer, which led to inconsistencies and was a risk to public safety. Investigator Alvarez got up here and told you that she tried again and again to warn the city that these policies were dangerous.
that they had to make changes. But the only change they did make was to fire her. Without detailed guidelines, something like what happened in Cole was bound to happen. Which brings us to number 2. The city knew the risk of harm. They knew that the canine they deployed, Max, had already bit 2 other children before. They were on notice that this dog was dangerous, but they chose to do nothing about it because they didn't want to spend more money on training. They knew the risk, but they didn't care. Which brings us to number 3. Officer Davis's conduct was unreasonable. Because on that day, Cole didn't have guns on him, didn't have drugs. He didn't display any risk of danger. And yet, Officer Davis loosened his grip on his dog's leash, allowing him to leave deep puncture wounds on a child, only giving the command to stop after he had already sunk his teeth in for several seconds. That is excessive force. We are here today because the city of Blue Note cut corners with the canine. And Cole suffered the consequences. Bring justice to a little boy who could not defend himself and find the defendant liable.
Thank you, Ms. Paltier. Mr. Veronica Torres, when you're ready. Closing on behalf of the plaintiff as well, correct?
Correct.
Yes.
They knew, they ignored, and they failed. This is a case of a city that saw warning signs, ignored them, and put a child in dangerous position. And unfortunately, that risk became real when Nat Cole, a 13-year-old, was severely injured during a drug sweep on his way to school. So we have brought a Monell claim, which means that we have to prove to you 6 elements, but only 2 of them are at issue here. And that is that the city's inaction and deliberate indifference was the leading cause for Nat's injury. We have to prove that to you with a preponderance of the evidence, which means 50% and a feather. But we embrace that burden because we have done that exactly thing today. We did it in 3 ways. Because they knew, they ignored, and they failed. Let me turn to my first point, which is that they knew. You saw in the BPD canine report that Max, the canine that attacked Nat, had a long history of aggressive behavior. He was involved in an incident of aggression every year for the last 4 years. And 2 of those incidents resulted in injuries to teenagers. You also heard from Monica Alvarez that she expressed concerns to her lieutenant 5 days before Nat's attack. She expressed concerns because she was concerned about the use of that canine specifically because of his long history of aggression, but also because of the confined space of that bus and the unpredictable nature of children. She knew that all of those 3 elements combined would lead to a high risk of injury. She advocated for policies and checklists to ensure that deployment of canines around minors were safe. In summary, the city knew that there was an obvious and high risk of injury in that operation. Which leads me to my second point, that despite knowing the risk, the city ignored them. You heard today as well that the city had a legal obligation, or there was a procedure to report to the state agency all canine bites. But the city failed to do that, knowing that it would lead to an internal investigation that could have led to other policies and procedures. It's almost as if you were driving down the freeway, and then all of a sudden the dashboard lights came up. You knew that it could lead to an accident, but then chose to keep on driving. That's exactly what the city did here. Monica Alvarez kept warning them that this could lead to danger, but they chose to ignore her. You also, which leads me to my final point, that the city failed. The city knew of the risk. They did not act upon them. And as a result, not Cole got injured. Thank you.
Thank you. Seeing as there is no closing argument on behalf of the defense, congratulations. That concludes our trial. I want to congratulate both of you on making it to the final round. Your performance today was a testament to the hard work that you both put into this. Fantastic job, both of you. I hope that you're really proud. I know that your supporters sitting in the back are very proud of you as well. I want to remind you both that we have a reception tonight from 5:15 to 6 p.m. right here in the courtroom. And it's at that time that we'll be presenting the individual awards as well as the top 3 advocates. So please come. Hope to see you both there. And again, just congratulations. That was very, very nicely done. And again, if you haven't signed up to be a bailiff or a witness, do so. Okay. Thank you all for joining us. Everyone at this time, once Ms. Baltiera, and you don't have to rush, once she's able to get her stuff, we'll just have everyone exit the courtroom. We're gonna crunch the numbers and get everything all ready, and then we'll see you guys here in a little over an hour.